Mr. President, good morning. Now, for the convenience of members to make preparations earlier, I have decided in relation to the two members' motion on the agenda, which do not have legal binding effect, I will defer the two members' motion to the 19th of March. That means after we completed this bill, we still have two motions to deal with. As to the two non-legally binding members' motions, they will be deferred to the 19th of March. And we're on page 74 of the script, clause 17. The Secretary for Transport and Housing has given notice to move the Fourth Amendment in Annex 1 of the script to amend Clause 17, which seeks to make a technical amendment to the proposed Section 70, bracket 2. Mr. Dennis Kwok has also given notice to move his Second Amendment in Annex 1 of the script to amend Clause 17, which seeks to add subsection 4 to the proposed Section 70 to grant exemption to minors in paying buyer stamp duty when acquiring properties. Ms. Lee has also given notice to move her Fourth to Seventh Amendments in Annex 1 of the script to amend Clause 17. The Fourth to the Seventh Amendment of Lee seeks to set out expiry dates for the relevant provisions in relation to charging additional special stamp duty and buyer stamp duty. And the committee stage will first deal with the Fourth Amendment moved by Secretary for Transport and Housing in Annex 1 of the script. Whether or not this amendment will be passed will not affect Mr. Dennis Kwok and Ms. Lee in moving the relevant amendments. And regardless of whether the Second Amendment of Dennis Kwok is passed, Ms. Lee may still move her Fourth to Seventh Amendment. And if Mr. Dennis Kwok's amendment is passed, I have grant permission to Ms. Lee to amend her amendment to Clause 17. If Ms. Lee's Fourth Amendment is passed, she may not move her Fifth Amendment. Regardless of whether her Fourth or the Fifth Amendments are passed, Ms. Lee may still move her Sixth Amendment. If the Fourth or Fifth Amendment are passed, I have given leave to Lee for her to amend her Sixth and Seventh Amendment. If the Sixth Amendment is passed, Ms. Lee may not move the Seventh Amendment. I don't know whether members can memorize what I have just said. Members can now have a joint debate on the original provision of Clause 17 and the relevant amendments. I will now invite Secretary to speak and move the motion, followed by Mr. Dennis Kwok and Ms. Lee, but they may not move amendments at this stage. Secretary. Chairman, I move my Fourth Amendment in Annex 1 of the script to amend Clause 17. The relevant amendment is a technical amendment, and the amendment will not make any substantive changes to the bill. The government's CSA seeks to stipulate that for instruments to which the additional special stamp duty is payable, if the existing SSD rates have been paid, whereas the additional amount has not been duly paid, the IRD may only charge the additional amount or levy penalty on the additional amount. I understand Mr. Dennis Kwok and Ms. Sari Lee have moved amendments to Clause 17. The government doesn't agree with the amendments, but I shall give a more detailed reply after listening to members. Mr. Dennis Kwok.
In my speech earlier yesterday, I've explained in full my reasons for putting forward the present CSA. I shall not waste time in repeating in full my reason for doing so and my arguments behind the CSA, but suffice to do that we are to refer to the central principle in our rule of law and our legal system, which is that of certainty. I believe that this is not a principle which is new to us, nor is it something that we are making up in order to support the CSA. Certainty is a principle that is central to our system of rule of law. And I shall repeat briefly what the Chief Justice, the former Chief Justice, said in the Court of Final Appeal judgment of Solicitor versus Law Society of Hong Kong. Certainty in the law and predictability and consistency in its application are of great importance. They provide the foundation for the orderly conduct of commercial, business, and other activities. And that is why we believe that the CSA, as proposed by me, is cardinal to ensuring that there shall be consistency and orderly conduct of commercial transaction, especially when it comes to the acquisition of properties, which this bill deals with. Now, may I begin with the crux of the matter, because the reason why we are facing the present dilemma stems from the way this bill was drafted, and in particular, Section 1, subsection 2, which states that this ordinance is deemed to have come into operation on the 27th of October 2012. Now, this very provision is extremely unusual. It's unusual because no bill would have the operation date, very rarely stated retrospectively from the 27th of October 2012, meaning almost 2 years from the date when it comes into operation, almost 18 months. The reason why we are in the present dilemma is because the way this bill is proposed. It is unusual because it is not a subsidiary legislation, but it takes the form, in effect, of negative vetting. It comes into operation immediately without any legislative scrutiny. And we pretend that this is a blue bill. In the Secretary's response yesterday, he said, well, you can't take up the blue bill and pretend that every provision in the bill will come into passing at the end of the day, because this is only a blue bill. So no one, including lawyers, can treat every provision, including the exemptions, as being the law of the day, because it may not be passed by the Legislative Council at the end of the day. True, but in the usual course of matters, that is of course true. No one will run around and say, holding a blue bill, saying this will be law, so we better act in accordance with it. But the unusual feature of this blue bill, as I've pointed out, lies in Section 1, subsection 2. It comes into operation immediately, and it acts, in effect, as a negative vetting, although you don't call it negative vetting. But what's in the name? As Shakespeare said, that which we call a rose by any other word would smell as sweet. That Romeo would, were he not Romeo called, remain that dear perfection he owes without title. This is, in effect, negative vetting. In effect, although you don't call it negative vetting. And the reason why we are in the present dilemma, if you look at Article 76, as my honorable friend Ronnie Tong pointed out, every legislative enactment is supposed to go through the legislative scrutiny of the Legislative Council before it is passed into law. That is how our system works, and that is why the administration is facing so many problems and so many arguments over this bill, because it is not following the usual procedure of legislative enactment, allowing this council to have a full debate, full deliberation before this bill comes into operation. Now, be that as it may, I understand the administration is taking an unusual measure in unusual circumstances by putting forward special stamp duties in order to stamp the heat of the housing market. We understand the policy objective, but it still remains the case that this is a very unusual way of putting forward a legislation by allowing it to come into operation retrospectively on the date of its announcement. And this is an unusual feature which the administration must accept. This is not how things are done in the usual way. And that is why when you take away exemption, which you have announced, which you have represented to the people in Hong Kong, that such exemption will take place, that you can't simply, on a U-turn or on a sudden change of policy, decide retrospectively that, now we're not going to have this exemption because of whatever reason. So whoever fools out there believe that this exemption would apply is to their own fault. They have no one else to blame but themselves, because this is only a blue bill. But this is not how a responsible government should behave, because you know very well this bill will come into operation on the 27th of October 2012. You know this is a very unusual procedure, and you know that people rely on your representation, not only by way of the bill, but also by way of the staff at Inland Revenue, who's been repeatedly telling people that Hong Kong permanent resident minors will be exempted from paying special stamp duty. But on a sudden U-turn, you change that policy, disregarding all the representations, all the transactions that people have relied upon that representation in making. So this is an unusual legislative procedure. And that's why we put in the CSA, to remedy the effect of a sudden U-turn or change of policy on the part of administration, not allowing the stamp duty to bite on transactions that has already entered into prior to the gazettal date of this ordinance, so that transactions or people who have relied on the representation of the administration regarding the exemption will not be affected, so as to reduce the retrospective or uncertainty that will be caused by the sudden U-turn or change of policy on the part of administration, so as to reduce the uncertainty that will be caused by this bill. And it comes back to the reason why we believe the CSA is important in preserving that cardinal principle in our legal system, that is of certainty. Mr. President, I shall, if necessary, rise again to address some of the replies or comments made by my colleagues. But there's only one point which I would address, which the Secretary has raised yesterday in objection to my CSA, which is that my amendment only comes into effect on the gazettal of the bill. But and during that period, he say it will cause further uncertainty. We're talking about a matter of days before you gazette this bill, once it is passed. It is absurd to say that there will be numerous minors rushing to buy properties before the gazette of this bill. You're talking about matters of days. You could do it as soon as possible. And I think it is an excuse to say that it will cause further uncertainty, when the very uncertainty that is being caused is your U-turn or your sudden change of policy, which we are trying to address. President, thank you.
Mr. Reedy. Mr. Chairman, this joint debate is on granting exemption to local minors in paying SSDs and BSDs when acquiring properties, and also the expiry dates in relation to the relevant provisions. Now, I'd like to talk about the sunset clauses, the sunset clause proposed at the BC meeting, and I'm going to move on behalf of the Bills Committee the 4th to the 7th amendments. That is the relevant provision should expire on the on the midnight of the 31st of December 2014. That is proposed by Mr. Tommy Cheung, and I'm moving on his behalf. And for the Fifth Amendment, in relation to the proposed Section 70, to add subsection 4 and 5 to stipulate that the relevant SSD provision shall expire on the midnight of the 26th of October 2015, and that was proposed by Mr. Andrew Leung at the Bills Committee meeting and endorsed by the committee and moved on his behalf. The Sixth Amendment has to do with the added subsections 4 and 5 to proposed Section 70 to stipulate that the relevant provisions of bias stamp duty will expire on the midnight of the 31st of December 2014. And the Seventh Amendment is the additional subsections 4 and 5 to the proposed Section 70 to stipulate that the relevant provisions of the bias stamp duty shall expire on the at the midnight of the 26th of October 2015. And this was proposed by Mr. Andrew Leung, endorsed by the Bills Committee, and moved on his behalf. The Bills Committee discussed at length whether a sunset clause should be introduced, and some members believed that objective and quantifiable indicators should be set out for the government to assess the effectiveness of the measures and for speculators to assess the risks and also make informed choices before acquiring properties. Some members urge the administration to introduce a sunset clause to increase certainty for the community and the business sector, and also to maintain their confidence in the healthy development of the property market.
Some members of reservation, because there isn't a single indicator to reflect the conditions of the property market. It is complicated, and also we're subject to external factors. So if you predetermine a date for the bill to expire will not be necessary. This will also dilute the effect of the bill. The administration has also promised that within a year of the passing of the bill, there will be a review and the LegCo will be given a report. For the details of the deliberation of the Bills Committee, you can find them in the report of the Bills Committee. I'm sure members have already received a copy. Here I'm speaking on behalf of the Bills Committee. I'm moving the amendments on behalf of the Bills Committee, so I will rather give the floor to members who proposed the amendments and other members to speak, and then I will come back to the position of the DAB in relation to the CSAs discussed here. Thank you. Mr. Andrew Leung. Mr. Chairman, I have proposed two amendments concerning the sunset clause. In other words, the two items are moved by Mr. Lee on my behalf, or on behalf of the Bills Committee. That is, there should be an expiry date, so to speak. That is on the 26th of October 2015, midnight. This is because for the SSD, it will come into expiry on the 26th of October 2015. So that we are aligning the various provisions. We want to have something in black and white, and then there will be an expiry date for us to review and cancel the measures. For a free economy, I don't think we should have something which is blatantly discriminatory, especially corporate buyers in taking out residential properties. During the scrutiny of the bill, we have been told by officials that Hong Kong is not a single place in the world to have a buyer's stamp duty, but that this is an administrative intervention and it is quite rare internationally. According to the administration for Macau, which has also got a special stamp duty, there was a review 2 years within the introduction. In other words, at appropriate moments, a review on the stamp duty is indeed necessary, and that's why the BPA has asked for a sunset clause to be introduced. It won't send out a wrong message to the market. Not only that, but also it is more in line with the intention of the bill. It will provide an additional safeguard for the long-term stability of the property market. When the SDH said in his second reading speech that a sunset clause would send out the wrong message and stimulate demand, I can't agree. With tapering off of the U.S. and also the interest rates starting to rise, I think there is a downside risk in the property market. Negative assets may also re-emerge. As a responsible administration, I think officials should learn from the lessons of history. In due course, I think there must be a very cautious re-examination of the effectiveness and necessity of the demand-side management measures, as well as the rates of the stamp duties involved, so that the public and the market will have a clear idea that the government is determined to review it. And that's the best approach. And the best approach is to have a sunset clause, and that's my justification. This is because in an exceptional time, when we introduce a extraordinary measure, it is necessary. The BPA agrees to that, but then it shouldn't be exceptionally long as far as the duration is concerned. So the administration must show the public that it is determined to gain time to do the job properly. Say, for example, have more land supply and also adjust the construction costs as well as the land costs. So what the administration has to do is to show its determination that there will be an increase in long-term land supply. If I may also address the point made by the STH during the first round of spirit voting. We have been accused of lacking a consensus. Indeed, there is. Otherwise, the chair of the Bills Committee cannot have moved the CSA on our behalf. Individual political parties would have different voting intentions, but on that particular day, there was a consensus in the Bills Committee to ask Mr. Lee to move the CSAs on our behalf. So I hope the STH will put this will include this in his consideration.
I will first speak on the CSA amendment of the Honourable Dennis Kwok. I'm sorry that he is not here to listen to what I have said. His speech has given me an insight of the civic party's sudden, and better than not having it, sudden resurrected sense of justice. Had he not supported the Honourable Regina's Yip CSA vis-à-vis the government's machine of taking over the CSA, he would not have created that uncertainty. By civic party having supported that government CSA of depriving the 18 years old right to own a property, as he gallantly defended that the drafting of the bill, not only the drafting of the bill, the very nature of the bill that the government have initially expressed that they have given the right through equality, through the basic law, the 18 years old Hong Kong permanent resident, or 18 years old, under 18 years old Hong Kong residents do have the right to purchase property without the payment of 15%. The civic party members, to many citizens in Hong Kong, they were perceived, I use the word were, perceived to be the defenders of the faith in defending our core values. They were perceived to be the custodian of the protection of rights of citizens. That's how the Civic Party originated from the 45 Concerned Group. Now, yesterday, they have done something completely different. I have challenged the Civic Party to debate with me why they have not said anything when the original drafted bill gave the rights to the under 18 HKPRs. They said nothing. And at the same time, when the government CSA was tabled, I have also asked them to say something. They said nothing. So they make their bed of thorns. They have to be prepared to lie on it. And now, in his CSA, Dennis talked about certainty, which I totally agree with him, and talk about predictability. But why seek certainty when you have created uncertainty because you have supported the government CSA? I personally support your CSA to the extent that you are removing some sense of uncertainty from people outside this who has not been protected as they are originally being believed to have been told that they have that rights. Dennis, as a barrister, and as a person that I know you very well to the extent that you speak the truth, but somehow silence to the truth, as I said earlier, is worse than ignorance of the truth. I really don't understand why Civic Party supported the government CSA on the under 18. Mr. President, although Dennis Kwok has come out and with his CSA, but the very nature that he has supported Regina the government CSA, despite this matter, I found his CSA reasonable, and hence I tried to ask myself to support him. But righting a wrong for a period of time, when in the original place, the whole concept is wrong. Why don't you do it? As pointed out by the submission, as I think Dennis yesterday actually raised a case by the Messrs. Wong, Hui and company solicitors. The original bill excluded from the BSD, I think that was the case that you referred, adults who signed sale or purchase agreement as trustee for Hong Kong minors. After the bill was consented, the Inland Revenue openly confirmed this position through Q&A and articles published on its website and through its telephone inquiry services. It turns out that many people have been deprived by the unforeseen U-turn in stripping the Hong Kong permanent resident minors of the BSD exemption. I think this was the case referred to. If I'm wrong, tell me. Clearly, it will be unfair to those relying on the original bill, as you have stated earlier, and the representation made by IRD and the government officials in this council. Those people have signed agreement to act as trustee for Hong Kong PR minors before aware that the government would have accepted the Honourable Regina's Yip CSA and withdrew and removed the exemption. The government would easily reply you, Mr. Kwok, nobody asked them to buy. Nobody asked them to listen to government. This government always changes its mind. The certainty is don't buy until the law is passed. They don't care about what misrepresentation is all about. They're not lawyers. Or even if they're legal advice, they have different legal advice. They choose to listen whatever they decided to. The government ought to make known to the public that this withdraws an agreement signed by the adults as trustee for Hong Kong PR minors before the announcement will be effected. The administration says that the suggestions not to apply the relevant CSA to acquisitions of residential property by Hong Kong PR minors through their trustee or guardians before gazetting the amendment ordinance would be contradictory to the principle of processing bills and would cause the public unnecessary confusion regarding the BSD regime. However, it is obvious that it was the government that first confused the market by disseminating erroneous messages. Now, the whole concept that the opposition camp yesterday voted against the negative wetting, and now that you have, in a way, asked the government to grandfather those people who have purchased before the gazetting of this ordinance. So you are actually asking them to eat back you're challenging the very nature that the government put forward on the negative wetting. This is something new and something that the government could consider, but they won't. But nobody to be blamed. The only one to be blamed is Civic Party. Had you and the opposition supported me in my opposition to this amendment, we don't have to face this music. Thank you for doing that. And now I cannot support you because I cannot use one right to remedy a wrong. The wrong itself is wrong. Thank you, Mr. President.
Wai-king,
Mr. O'Reilly. I'd like to give the position of the DAB on these amendments. On the amendments proposed by Mr. Dennis Kwok, as a member and the chairperson of the Bills Committee, I recall it was only at a rather late stage that the amendment was put forward to the Bills Committee for consideration. By then, we've completed our discussion on Mr. Regina Ip's proposed CSA, and we were already informed that the administration would take over her CSA. Now, on the points made by Mr. Dennis Kwok yesterday, I listened to him very carefully. When we received Mr. Dennis Kwok's amendment, I see reason for that. Because at the time we were talking about withdrawing exemption to children. Now we know we don't want to affect other people, and we know there's just a handful of such cases. But having checked with the administration, we find out that they're against it because it's against the general legal principle. That is, no one should assume that a bill would be passed in its entirety before the bill is actually passed. There shouldn't be undue expectation. So having heard that argument, I find that it holds water. Because before a bill is passed, we cannot assume that it will be passed easily. And therefore, now we should give exemption on such expectation. Of course, different people have different views. Mr. Kwok is from the legal profession, and the administration's arguments also advanced by legal professionals. But there's something I don't quite follow. I'd like to ask Mr. Kwok this. Mr. Kwok points out that this approach is rare. Because in the Blue Bill, there is a retrospective effect. So for these poor people, they will suffer. Now, perhaps you or other legal professionals can tell us, is it true that this only happens in this particular bill? Because in our consideration, if the administration's arguments stand, I want to support the administration because I don't want to set a precedent. That is, in future, we will be considering a bill before the bill is passed, and then members of the public do something based on the Blue Bill, and then they come and make a complaint to members, and then we give them assistance, we give them exemption. Well, it doesn't make sense if we do that. It's not reasonable. That's why I would like to, first of all, get more information and seek some clarification. Now, for BC members,
we have asked the administration to do with this loophole. We don't really want to affect these buyers, of course. That's also the position of the DAB. Perhaps the minors, through their parents or guardians, they have bought these properties with honest intent. But then the legal advisor, our legal advisor and the government's legal advisor said that their lawyer should have reminded them that the bill may be passed in a different form. There is a chance that there will be no BSD exemption. So on this legal point, I wonder if someone could answer my questions so we could get a better understanding of the situation. Thank you. Ms. Ann Chan. Thank you, Mr. Chairman. On the sunset clause, if you think about it carefully, it's illogical. Now, yesterday we debated the negative vetting procedure. Let's say there is something of substantial interest and is announced with advance notice, then definitely it would lead to an impact on the market, which we could not predict how far it would go. Now, if we say that by on the 31st of December 2014, the stamp duty ordinance will become void, then definitely nobody would buy any properties from now until the end of the year. Perhaps on the 1st of January 2015, no one would want to go on holiday. They would all be queuing up to buy properties. Now, the government has introduced these drastic measures as a means to regulate the market and supply and demand. It's like the export restriction on baby infant formula milk. Some members also suggested a sunset clause. But the administration has to respond in a responsive manner and refuses such a request. Now we want to roll out a measure quickly because of a sudden change in the market. If the market restored to its normal operation, when the government has managed to regulate the market, then I'm sure the relevant measures will be withdrawn. Electoral members, of course, have only the power to make laws. And we also have the power, actually, to repeal laws. I'm sure at an appropriate juncture, some members would propose such actions. So whether it's the infant formula export restriction or these two drastic measures, they're in response to public demands. The public would like to see the two drastic measures be passed in this council as soon as possible. I also support these measures because they were introduced for the good of the community. They were introduced in response to public demands. Thank you. Mr. Christopher Cheung. Quantitative easing was introduced by the United States. Capital assets have seen their prices soar. Hong Kong could not stay out of this. In the past few years, property prices kept soaring and spiraling. They are now way beyond the affordability of the general public, so there are much public grievances. For the new term of the government, it wants to curb such usual exuberance in the property market. It tries to cool down the property market. That's why it's introduced these drastic measures. The public welcome it, but then some political parties But some may resort to all sorts of means, and some will be affected. Some innocent parties may be affected. I'm talking about BSD exemption to minors, Hong Kong PR minors. Now, we support giving BSD exemption to Hong Kong PR minors, but now the government is going back on its words. It wants to recover the stamp duty from the 26th of October 2012 for transactions involving HKPR minors. And so for those HKPR minors who've acquired residential properties through their trustees or guardians, they are now caught in this awkward position. They don't know what to do. Now, how can you answer to these people? Here we're talking about not an insubstantial sum, because these days a property costs at least $6 or $7 million. That means people have to pay an extra $700,000 or $800,000 in stamp duty. If it's a more expensive property, some may have to pay an extra $1 million in stamp duty. Now, I know people who thought they didn't have to pay stamp duty, so they bought properties, but now they will be pursued by the government. But they are really angry because they are not speculating. They are Hong Kong PRs. They're just buying properties for their children. This is to remove the uncertainty facing their children in the future. But then the government all of a sudden changes its mind, so they're caught now. And they have to pay a substantial amount of stamp duty. All of a sudden, they ask why the government could be so unreasonable. These measures are supposed to target speculators. How come innocent Hong Kong PRs are also caught in the process? Last month, the government suddenly accepted Mrs. Regina Ip's proposal, and there will be complete withdrawal of the BSD exemption for Hong Kong PR minors buying properties through guardians or trustees. And the government would not accept Mr. Dennis Kwok's amendment. That is for transactions made between the 27th of October 2012 to the from the 27th of October 2012 to the Gazette of the Bill. BSD will be exempted for HAPR minors buying properties through guardians or trustees. I believe this is a reasonable measure. Now, the government suddenly changed its position last month, and it's almost a year since you first made the announcement on these two measures. So when people bought properties, they bought so on the understanding that there would be BSD exemption, so they bought properties for their children. But now the government plans to change the bill. How can the government renege on its promise? How can you expect people to trust the government again? Now, the government is being unreasonable and it's not honouring its words. It will only undermine people's confidence in the government. I hope the government will learn from this answer. I speak in support of Mr. Dennis Kwok's amendment. Thank you. Mr. Dennis Kwok. Mr. Chairman, I'd like to respond to the questions raised by a few members. Ms. Darley asked if this approach is rare. Within our constitutional framework, the law-making process is such that there must first be scrutiny by the Legislative Council before something comes into effect. But of course, for some subsidiary legislation, there could be negative vetting. Or in this case, the bill will first commence before we scrutinize it. Yes, this is possible. But for principal legislation to take effect first before scrutiny, and it affects the rights of many people, this is rare. Now, when we consider the export restrictions on infant formula milk, again, for that bill, it took effect before we scrutinized it. But then eventually we found there was something wrong with the bill and people were wrongly arrested, that it caused a dispute. The administration's response was for bill carrying criminal liability. Usually they would not do it this way. That is, for the bill to take effect first before scrutiny. They will only do so in truly exceptional circumstances, because because people may have to be held criminally liable before the bill is actually passed into law. So this approach is rare. Now, this blue bill before us, the way it's dealt with is also rare. Usually for most ordinances, it would not be done this way. That is, for the bill to take effect first before it's scrutinized by electrical. Now, so after October 2012, if any provisions in the bill are changed, that may affect many people involved in property transactions. Their rights may be undermined. Mr. Christopher Cheung just cited an example. He knows a friend and how he's affected by this change. So I don't have to go into the details. That is, you bought a property thinking you did not have to pay BSD, but now you would be pursued by the government to pay the BSD. So it causes a lot of hassle. Usually it will not be done this way. But if we're talking about exceptional circumstances, here we're in exceptional circumstances. This is an extraordinary measure to curb, to deal with the property market. But still, you can't just say that I will change my position from day to day. Today, I'll tell you, yes, I'm giving this exemption. Tomorrow, I'll say, no, you're silly. This is not yet the law. If you believe in us, sorry, you've got it wrong. So how can you then expect the government to expect people to believe in the government? How can you expect us to believe in your verbal undertaking, albeit it's made solemnly? Now, you've written this in the blue bill, and IR is telling people you get an exemption, but then tomorrow you say, oh no, we're changing our position. Then how can you expect the public to believe in you?
但係你做都唔可以做到咁離譜。如果你真係改嘅話，起碼你俾翻嗰個喺嗰段時間信咗你嗰啲人，佢哋買咗嘢透過監護人或者信託為子女買咗樓宇嗰啲啦，起碼佢哋唔應該受到影響咯。咁你都話頭先局長都有講過話，相信呢一類人其實唔係好多。咁如果唔係好多嘅話，佢哋對樓市對價格所造成嗰個嘅影響都唔係咁多啦。個稅款亦都唔係話數目會好大啦。咁點解你一定要去
significant impact on these people? So
my honourable friend Abraham Sheik's grave allegations that the Civic Party has been neglecting its duty in defending the rule of law and our legal system and the rights of the Hong Kong citizens. As I've pointed out, I think there's been a fundamental misunderstanding that my friend is misconceived in his argument that we are not somehow protecting the rights of Hong Kong permanent residents minors by supporting the CSA proposed by Regina Yip. That is not so. In the eyes of the law, as I've said yesterday, in the eyes of laws, we've always treated minors as somewhat different from adults. As any first-year law student would tell you, that minors do not have the legal capacity to enter into transactions. And that's why the law required them to enter via trustees and guardians. We've always treated minors differently. It is not discrimination, nor is it unequal treatment. Now, if Mr. Sheck wants to argue that we should perhaps lower the age of voting to below 18, I'll be happy to engage him in that argument. But the fact remains that the law has always treated minors as different. So as a matter of policy, when it comes to this bill, we can then have different views on whether minors should be exempted. That is a matter of policy, not a matter of fundamental right. We may differ on whether, as a matter of policy, they should be exempted. We are of the view that they should not. by supporting this CSA. I respect you see the matter differently, but it is not, as you put it, a fundamental question of rule of law or the right of minors to acquire properties, nor is it discrimination. And in further reply to Mr. Shek's point about the need to deal with the retrospective effect of these exemptions not applying to transactions that were entered since October 2012, the law has always been very skeptical, very worried about retrospective legislative effect, especially those that has not been through the scrutiny of LegCo. We've always been very wary of that. That is true throughout the common law world, not only in this jurisdiction. I found last night a judgment handed down by the Canadian Supreme Court by the learned judge Dejong J, where she put it very succinctly, explaining why retrospective legislation are to be avoided at all costs unless only in exceptional circumstances. And she said, and I quote, "There are a number of rules of interpretation that can be helpful in identifying the situations to which new legislation applies. Because of the need for certainty, I repeat and I emphasize, as to the legal consequences that attach to past facts and conduct, courts have long recognized that the cases in which legislation has retrospective effect must be exceptional. More specifically, where legislative provisions affect either vested or substantive rights, as they do in this case, because you're talking about actual substantive right of people acquiring properties, and we know how important that right is in this jurisdiction. Retrospectivity has been found to be undesirable. New legislation that affects substantive rights will be presumed to have only prospective effect unless it is possible to discern a clear legislative intent that it is to apply retrospectively." So there you have it. The court, the Canadian Supreme Court, there very eloquently summarizes why we have always avoided retrospectivity in any legislation, because it damages the certainty of the law. And you are talking about past conduct and past actions being subject to the law, affecting the substantive rights of people. And that's why we oppose it as a matter of principle. And that's why we need to pass this CSA. That's why we move this CSA, so as to address this problem that will arise whenever you have a legislation affecting substantive right, having retrospective effect. It is not to be desired. It is undesirable. And we are trying to reduce the uncertainty, the negative effect of this legislation. Thank you, President.
Mr. Kenneth Lau. Thank you, Mr. Chairman. Now, on the 4 sunset clauses, I'd like to respond to them. They have to do with the SSD stop taking effect by midnight on the 31st of December 2014, and the SSD expiring on the 26th of October 2015, and the other 2 in relation to BSD cease to have effect by midnight on the 31st of December 2014, and also expiring by midnight on the 26th of October 2015. Now, let's look at the history of sunset provisions. This is not common among common law jurisdictions. Sunset clause or sunset provision originates from Roman law. Now, among the jurisdictions adopting Roman law system, the United States is the country more often using sunset provisions, but still it is not very common. Sunset provision seeks to cause a particular provision or particular section of the legislation to cease to take effect or for the purpose of enacting new provision. I've checked the Hong Kong laws, the laws of Canada, and the laws of UK, and I can say that sunset provisions are very rare. Now, to quote an example, in 2005 in the UK, they passed an act, Prevention of Terrorism Act 2005, and that act was very controversial because it involved fundamental rights and personal freedom. And the Labour Party led government introduced the bill for first reading in the House of Commons. It was the 22nd of February 2005, and the backbenchers of the Labour Party were very dissatisfied, and they refrained from voting. Now, the Prevention of Terrorism Act 2005 authorizes the Home Minister to give control orders to suspected terrorists to restrain their personal freedom. And by imposing control orders, the suspected terrorist can be confined to his home, and he could be prevented from using his internet, his telephone, and information can be obtained in relation to his online activities. And this act had significant impact on a person's personal freedom and fundamental rights. The act was introduced swiftly to tackle issues going on at the time. And when the act reached the House of Lords, the Lords introduced a sunset provision in the act because the act was so controversial and it also hinged upon personal freedom. This is a good reason why we need a sunset provision, and it will only be introduced under exceptional circumstances. Now, in relation to this bill, about the changes made to the SSD or the BSD introduced, they seek to regulate the market, and they seek to regulate consumers' behavior. Our economy and our property market are dynamic. We're not omnipotent. We don't know by the 31st of December 2014 or the 26th of October 2015 what is going to happen. What will happen to the property market, whether it will be exuberant or what. If if the market goes up by 50%, then isn't it foolish to have the provision cease to take effect? And from now to 2014 to 2015, even if market remains stable, does it mean that nothing will happen because everyone will be observing the market and wait for the BSD and SSD to cease to take effect by then? So I don't know why we have to stipulate the two expiry dates. Of course, you can also impose conditions in the sunset provisions. For example, let's say when the economy has changed, or when the QE measures have tapered, or when the market has gone down by 30%, the provision can cease to have effect. But this is not accurate because we are talking about a piece of legislation. Economic circumstances must not be attached too much importance. So I don't think it's appropriate to include the sunset provision in a piece of legislation that seeks to regulate the market. And in fact, for sunset provisions, in terms of the Hong Kong SAR's legal framework, it doesn't enjoy a high status because I checked the laws of Hong Kong, and so far we don't have any sunset clause in the current legislation. And LegCo members have the constitutional right to scrutinize every bill. On the other hand, when the piece of legislation is scrapped or repealed, the usual practice is to let LegCo pass a resolution to repeal the piece of legislation.
Thank you, Mr.
Mr. Abraham Shen.
Dennis actually has raised a challenge for me to debate with him, but I'm not engaging in a legal debate, which I'm not as learned as you are. Secondly, I'm not a barrister. I'm just a common man seeing common rights, seeing common practice. On that basis, from a common man perspective, to see what justice is all about. You talk about that children's minor rights is different from adults' rights. That is wrong. When a child is born, he is born with that right, or he is given the rights. How the rights is being actually implemented, that's a different matter. Because he's a minor, he needs guardianship. So don't confuse rights and application of that rights. Mr. Kwok, I mean, you are a lawyer. I might not even be a first-year student, but as a common man, I know what's common man sense of justice. Why didn't you talk when the government said that they have the rights in the first place as in the bill? Why didn't you raise query when the government withdrew this right? From a legal point of view, don't you see there is a big differences? My dear learned friend, speak the truth. And this is why I said your CSA, I tend spiritually, I support it because you try to right the wrong. But why do you support the wrong in the first place? If it's wrong, you can't find it into a right path. That is the essence. You talk about retroactivity. I totally agree with you. That's not what we used to. But this government, they are God. They play God. They decided when. They use emotion. They use feelings. They use a sense, their personal judgment. They don't talk. Making law, we do away with all this. We talk about logic. We talk about reason. Do they have reason in this bill? Taking minors right away? Come on, defend it. Don't defend yourself because you have supported. It doesn't matter. If it's wrong, it's wrong. This is the essence of being a good legislator. This is the essence of being a good common man. 主席，我而家想講。
Mr. Chairman, I would like to turn to my comments on the sunset clauses. If I may answer Mr. Kenneth Leung's points. Well, the Liberal Party and the BPA did not first propose the sunset clauses. I recall that it was the Democratic Party who first proposed the idea of a sunset clause. I cannot remember which bill it was. It's good to have James Toh here. Now, we have an extraordinary measure in exceptional times. So for this bill, Mr. Leung, yes, indeed, this is one. The property market is out of control. So the administration has come up with this bill. But then this bill is for the time being to face with the exceptional circumstances. So for this bill, why can't we have a sunset clause? As if you are saying that we mustn't have any sunset clauses. Now, perhaps the administration should have asked you to speak on their behalf. your speech sounded like the speech from the administration. You are saying that we can't foretell what will happen in the future. Now the administration is saying that we should have faith in them. When the market falls, then there will be negative vetting. When it goes up, then there will be a bill. But the administration is changing all the time. Don't use your own values to assess the administration. You should adopt their value system to assess them. Now, when you spoke, I thought I was listening to the STH, Professor Zheng. Now, you talk about the legal points. Did we not have it again? Please read the Hansard. I know you weren't with us before, but you can ask your colleagues on your side. Sunset clauses, ask Leung Kwok-hong. Sunsets, and sunset. He spoke on that for hours and hours. For a sunset clause, it means that we are putting the administration on the alert, reminding them that this is something for the time being only, not for the long term. Thank you. Mr. Reedy. Thank you. Mr. Chairman, I would like to thank Mr. Dennis Kwok for his reply. I haven't been convinced, so I would like to give a further response. In the Blue Bill, well, since the introduction of the Blue Bill, indeed, there have been some revisions as a result of the scrutiny of the bill by the electrical. Now, the DAB would like to plug the loopholes, and so we have to take away the exemption originally given to the miners. Whether you agree with it or not, it was the voting result of the electrical yesterday. Of course, we've heard the administration. We have heard the members' accusation that the administration is being arbitrary, but then the two loopholes were pointed out, and the administration is trying to plug the loophole. As to whether you think it is good, whether it is supportable, is something else. But then yesterday there was the voting, and we've come to a decision. So there is this revision. Now, Dennis Kwok is saying that this is a bill which has retrospective powers. It is rarely seen, and I can understand this point. It is only when we are in an exceptional time that we resort to extraordinary measures. I think probably there will be more sunset clauses in the future. Yesterday, we passed the revision mechanism to change the stamp duty rates. Maybe we'll face with something similar. Whenever we get a bill, we shouldn't assume that the legislature will endorse it in its original form. Otherwise, we would not have had 22 meetings, 44 hours of deliberation. To be fair to the trustees and the miners who have bought properties, I have sympathy for them, but must we give them exemption? Of course, you would say that it involves a small number of people, but I'm worried if it becomes a precedent. So perhaps Dennis should also address this point. We have asked our legal advisor on this point. As lawmakers, we don't want to agree to any revisions which will affect others. However, if it starts to become a precedent, that is, we have a blue bill, when there are changes, when there are CSAs, and then there will be another round of discussion of this nature. I did ask my lawyer friends, and then I was told that in theory, for extraordinary measures in exceptional times, at the time of purchase of the time of purchase of the property, the lawyers should have reminded the parties involved of the risk. They can't say that they know nothing about it. Indeed, it is quite difficult for them. But I hope that there will be sort of answers to my questions, and I hope that the administration can try to give further replies to this point. This is a very rare scenario. The administration and the legislature are now moving CSAs which will affect certain people. Did we have similar examples in the past, and how did we deal with them? So please elaborate on the examples. For sunset clauses, I think members who are in support will speak. I will listen to the views of members. I look forward to Tommy's thinking. He's from the Liberal Party. Now, we have got 2 days involved. For Tommy's proposed expiry date 2014, the 31st of December. It is not too far away. I haven't been convinced as to why he has picked this date, and it is a date very close to now. I hope members who are in support of the sunset clauses will speak so that I will listen to their arguments. Mr. James Tong, I'm speaking for the first time in relation to this joint debate. I thought Sally Lee acted like an official, saying that she would react when she have listened to members' speeches. I would have thought that the DAB has given this matter serious consideration. When she pressed the button to speak, I thought she would tell us about her personal views. Yet I was surprised to find that she would only give a further reply after listening to us. Now, if the DAB will only make up its mind after listening to us, I have full respect for you. But I find it strange. The DAB is well established as a political party. I would not have expected something like this to happen. I was surprised to hear this from her. It is a debate. Are you afraid of having a debate? You could also have said that this is merely an initial response and you listen to us. Are you an official? Why are you saying that you will listen to us first before you speak again? I'm sorry for saying this. Now, in relation to the retrospective powers, I hope you will understand that I'm actually referring to Dennis Kwok's amendment. Now we're talking about the imposition of stamp duty. Now we have to talk about what will be exempted. In other words, we're trying to confine the scope. Now, if you don't impose any restrictions, if you don't impose any limits, then the duty will be imposed accordingly. Usually, the stamp duty or a tax regime will come into effect after something has been gazetted. So when we act now, we follow the existing rules. Now, when we have retrospectivity, in other words, today we pass the bill, it means that we'll go back to what happened more than a year ago. Now, you have to bear in mind that no one can guarantee that a blue bill proposed by the administration will have the scope proposed, enacted, passed. However, once we start to make things retrospective, then you have to bear in mind that people do have reasonable expectation about the content of the bill. Part of the bill says that something is not chargeable. No, taxation is something mandatory. If someone has acted in accordance with your provisions, of course this is different from the criminal justice. Say, for example, we pass a bill and we say that certain acts will become criminally liable with retrospective effect. That is, when you first committed that act, you were not unlawful. And you did so with this expectation, and then later on you were sent to jail because of the retrospective bill. Now, of course, it will certainly be ruled unconstitutional in criminal justice. In civil cases, I won't say that you are not unconstitutional. But what about the equitable principles, as Mr. Abraham Shack has mentioned? So for what Dennis Kwok has said, I want to know whether it is equitable estoppel. Now, you made certain announcements, people do things accordingly, and then suddenly you say that it will be stamp duty chargeable. What is even worse is that it's the government that is taking this out. Had it been the case that a member is moving a CSA saying that certain things should not be exempted and be chargeable. Now, for taxation, by removing the exemption, there will be an increase in public expenditure. Had it been a CSA from a member, the government could have said that I can't help it. But then it comes from the administration, and the government is not being moved by arguments, thinking that it is all right. if you don't give this exemption, I think it's wrong. The government should have taken over Dennis Kwok's amendment so as to address the problem, the deficiency. Now, I think you should be fair towards the miners as well. I think the government should have taken over the CSA. The government didn't, and Dennis Kwok is now moving to CSA. Well, I think the CSA is good in that it can address this problem arising from the retrospective problem. It is all about exemption or not. Is there any other overriding principles? Are there any other overriding principles? I cannot think of one. Now, the government is only showing one principle to us. That is, if we get it our way, and then before the Gazetto, in the window period, there will be people rushing to buy properties. Now, there will just be a few days' time in the window period. How many people are there doing this, and how many flats are available? How many transactions would have been concluded, and how much tax would have been avoided? Now, for you to cite such examples, yes, Mr. Rinsky-Yuen, the D of the SJ, is behind this legal advice. But I have to say that this is very bad, out of proportion, unreasonable. This is your only argument for sunset clauses, Mr. Chairman. We have to make clear as to why we need a sunset clause.
That's because the government said this is a temporary measure, it's a special measure, it's not permanent in nature, it's not even a medium-term measure. This is in response to a set of special circumstances. Perhaps I could give an example to Mr. Kenneth Leung. He's right in saying that there is not any sunset clause in effect now. The sunset clause for rent control, that's been in effect for a long time. Every 2 years. Now, usually a tenancy agreement is for 2 years, but bear that in mind. And the government would review the rent level every 2 years. So every 2 years, the government review whether there's need to continue with the rent control. At that time, of course, it was the colonial government. Their thinking was, and there wasn't adequate housing supply. If there's no rent control and people kept increasing rent, people would have no shelter. So that was to support the 10-year housing program of Lord MacLehose. So that's why rent control is imposed, and the review was done every 2 years. At the time, they made it clear that the rent control measures were temporary in nature. Although this temporary measure stayed several decades, is unfortunate. We don't want this measure here we're talking about to stay for several decades too, of course. But at least you've been saying that this is temporary in nature. If there's a need, then it will be extended by a legislative resolution. But at least it will be extended every 2 years. There are many ways to come up with a sunset clause. There could be positive vetting. That means the legislature must have 31 votes in support for the measure to be extended. Or the design could be that it could be an automatic extension every 2 years unless within a certain time period, legislature moves a motion to stop the automatic extension. So there are many ways to do it. It's for legislature to decide whether this effect will stay on. I thought it was strange. It was done every 2 years, but the tenancy agreement was just for 2 years. In other words, the government was trying to tell the public they were truly determined in providing land. Whether they could eventually deliver was a separate matter, but at least they wanted to show the public that they were determined. So for rent control, there was a review every 2 years. But then, of course, the review could be extended for a long period because of lack of supply. Now, another implication of this is a compulsory review. So the government could give a solemn undertaking to say that we review it after a year. But what if you don't do it? What can you do about the government if it fails to conduct a review? But with the sunset clause, you have no choice but to conduct a review. That is, by way of legislative criteria, you have to review whether to extend the two drastic measures. You have to conduct a study, you have to do analysis, and then that will be the basis for extending the measure. So it's a solemn process because you need to amend the law to keep this going. But of course, out of administrative expediency, or actually government hasn't got any other measures up its sleeve, is actually a bit worried because it's such a weak government, so it dares not do it. They think if there's going to be a 2-year review, that they would be in trouble. So that is totally out of administrative expediency. Now, will people speculate on anticipation? What is the composition of the Legislative Council? How strong is the government? How much mandate does the government have? How strong would the public opinions be in swaying the response of LegCo? So this is already an interactive process. With confident government, with strong leadership, the government will tell something to the government, and the government will trust the government. That is, if there is a need, the government will certainly pass the measures, and if necessary, the government will certainly prevail over the circumstances. And if necessary, the government would certainly ensure LegCo will extend the measure, and if necessary, the government would certainly have sufficient land so they could cancel these measures quickly. But that's the way it should be done. But the government is so fretting about it because the government is weak now. It has no confidence. It's worried that if we have to come back to LegCo every 2 years, the public would not be sure if we could get it passed, even though it's supposed to be a good measure in response to the circumstances in the community. So, put bluntly, that's what it's about. I hope members understand sunset clauses are nothing to be feared. If the government proposes a sunset clause, it's just to show its determination to provide land. It just shows the government's determination to review the temporary measure periodically. And it's just a determination to show that the government only regards this as a temporary measure. But of course, 1 or 2 years later, the Democratic Party does not agree that a few months later the measures will be terminated. No, we don't think it's right. There should be a reasonable time frame. But after a reasonable time period, at least there should be a review. At least you should come back to LegCo again for another mandate. That's all it's about. So the sunset clause is like testing stone. Is to see whether the government is competent. An incompetent government would surely be afraid of sunset clauses. Mr. Kenneth Leung. If I may respond to Mr. James To and Mr. Abraham Sheck on certain issues about the sunset clauses. Here we're talking about sections 17, 4, 5, 6, and 7. Is about how we draft different forms of sunset clauses. Here we're talking about 4 sunset clauses. So what I said was limited to the content of the 4 CSAs. Well, yes, there are many ways to draft a sunset clause. It could be as Mr. James To has suggested. That is, we want to compel the government to review this arrangement. But then this has nothing to do with the 4 sunset clauses here, what Mr. James To said. On many different bills, many different forms of sunset clauses were proposed. Mr. Leung Kwok-hong, Ms. Wai-king, for instance, also proposed a sunset clause in relation to the surveillance on interception of communications ordinance. But then there is not a single sunset clause in effect now. If you look at the examples overseas, in truly exceptional circumstances, and where personal freedom or human rights could be undermined, there could be sunset clauses. But how do we draft and construct sunset clauses? We have to look at it to see whether the sunset clause is right. Now, for the 4 sunset clauses under consideration, I do not think they suit our circumstances. Mr. Abraham Sheikh asked how come I should judge the government on my personal values. Of course, that's the way I'll do it. I'm elected by 25,000 electors, so why shouldn't I be judging the government based on my personal values? The BSD, SSD are temporary measures, but if you ask me, I don't believe these are temporary measures. Many have said it many times that I don't believe that to be the case. That's why there should be no sunset clause. It's as simple as that.
To respond to Honourable Abraham Sheikh and Dennis Kwok's the debate about the exemption afforded to buyers of properties for minors, those children under 18, using a trust structure. Now, first of all, I'd agree with Abraham's observation that all men, women are born with equal rights. And only is the application of rights that is different, because, of course, as we all know, physiologically and psychologically, minors may not be capable of making fully informed and sound decisions. Now, even I've said so, I still agree with Honourable Dennis Kwok's committee stage amendment. What's wrong if we use a right to address a wrong? That wrong has been done yesterday. Now, if the government has a vision to accept my own amendment to introduce the concept of domicile, then you won't have to debate today. Now, of course, the concept of domicile is difficult, it's uncertain, but it's an established legal concept. Now, because the law here has retrospective effect, it is only equitable that those minors below 18 should be given the exemption for the grace period in between. If they buy property and they don't know the certainty of the legislation, they should be given the exemption. And I do not see a reason why the Honourable Abraham Sheikh that he cannot accept that to use a right instrument or a device to address a wrong. And the wrong has been passed and it's been done yesterday. Thank you, Mr. President.
Ms. Starry Lee. Mr. Chairman, I must respond to the allegations made by Mr. James To. The DAB's position on the sunset clauses is clear. If Mr. James To has followed my speech during the second reading debate, we do not accept the sunset clauses because no one could predict when the property market might be restored to normal operation, and then we could withdraw the measures. And then, of course, the property market in Hong Kong is subject to many different factors. So that's why we cannot support the sunset clause. So we've stated a position from an early stage. Just that at this point, I'd like to listen to members' views. If you think it's not right to listen to members' views, I think your comment is unfair and unsuitable. So I'd like to respond to Mr. James To. And on the dates proposed in the sunset clauses by different members, as I said, the 31st of December 2014, that's why I asked the Liberal Party to speak, because the 31st of December 2014, my own assessment is, unless there are any changes in the external environment, because we are not far from the end of 2014, how could we judge in such a short time that by that the 31st of December 2014 would be appropriate to withdraw the measures. What if there are external changes? We may need to have immediate measures to reduce the effect of the drastic measures. We may not have to wait till the end of the year. Now, we're told that the sunset clauses will show the government's determination to do something and is willing to review the matter at an appropriate juncture. But whether the property market could be restored to its normal state of operation, whether this malady of the property market could be cured, I'm sure we all understand, however hard the government works, the expected results may not materialize. Say within the term of the CE that he wishes to do a lot, but whether he can just achieve that is not a matter solely for the executive. We just talk about changing land use. There are various difficulties at the local district level. We talk about reclamation, developing new towns, developing Lantau Island. Inside and outside this chamber, there are a lot of difficulties. So it's not easy to substantially boost the supply of land. So we would say that 31st of December 2014 would be too soon, and even the 26th of October 2015 might be too soon, because if we set a date rigidly, that would really dilute the effect of the drastic measures at once. And as I said, it's not just for the government to work to do something about the property market. Apart from land supply, there are other external factors like liquidity in the market or the abundance of capital. Now, Mr. Norman Chen came to explain to this council that there could be a flight of capital. But looking at the market now, it doesn't seem to be the case. Just some time ago, we were telling young people or reporters, someone asked me whether it's now the time to go into the market for the first-hand residential flats. There is now more pressure on developers to dispose of the flats, and they noticed that various people are going into the market. So you're talking about flight of hot money. I don't see that to be the case. An interest rate, as we said during the second reading debate, interest rate could not be used as a tool to adjust adjust the property market. So there are so many uncertainties in the market. It's hard for us to decide when the property market might return to its normal state of operation, when would be the right time to withdraw the drastic measures. That's why I'm not convinced that we should have sunset clauses for the 31st of December 2014 or on the 26th of October 2015.
Sir Tommy Zhang. Chairman, now the administration has all along refused to give us an indicator on the effectiveness of the BSD and SSD, and the Liberal Party is very disappointed. Without an objective indicator, how will we able to know whether the measures can achieve their purposes? The quantitative easing measures are being tapered at the moment in the United States. Can we just sit on our laurels? The so-called policy is only the wish of the chief executive. Many investors tell me recently that without a stable environment and without stable and consistent policies, and if policies can change at the will of the government officials, then how can they be confident in making investments? And I can't deny that speculation in property markets have largely been controlled after the introduction of the SSDs and BSD. According to the indicators announced by the CNSD as of last October on private properties, for flats with 700 square feet or above, it still has risen by 0.4%. For a sellable area of 1,076 feet, the price has risen by 7%. And by introducing these measures, there are more risks in the property market, and sellers are less willing to sell the properties, and consequently, first-time home buyers dare not buy properties at the moment, and demands for home ownership has suppressed, but people turn to rent flats instead. Housing problem remains unresolved. How can you say that this is effective? With low transaction volume, property or real estate agents, decorators, other trades like logistic, cleaning, etc., they're all affected. All practitioners are affected, and in the submission by the Property Agents Association, this actually causes a lose-lose situation on the three parties concerned. On the whole, the economy is heavily impacted upon, and secondly, property owners don't or buyers in the property market don't enjoy their fundamental rights in making investments and purchasing properties for self-use, etc. Thirdly, the property sector is also heavily impacted upon, and real estate it's estimated that about 10 to 20% of real estate agencies will be closing, and some 10 to 20% of real estate agents will become unemployed. And with the tapering of the QE measures in the United States, interest rates may go up from 1% in the past. It has gone up to 2% or more. And the property market has cooled down somewhat, but it has nothing to do with the government's measures. It has to do with the external environment, including the possible increase in interest rates. Our view is very simple. We think the government should not interfere with the property market and should not involve the innocent. After all, increasing land supply is the only solution in stabilizing the property market. Now, Mr. Lee asked the Liberal Party why we have proposed such dates as the sunset clause. I don't know why she keeps asking me this question. I thought she has become a bureau director. I don't think there is a point in asking this question. If you have your position, you just vote against this amendment. You are from the pro-establishment camp anyway. So there's no need for me to explain. But anyway, let me tell you, we propose this amendment because by introducing a sunset clause in the SSD, the property market can in an orderly, gradual fashion, become a free property market again. And from now to 2015, it is opportune for the SSD to be scrapped because we still have 2 years in between. However, if the community is of the view that the date should be extended, then by publishing a notice in the Gazette, this date can be extended. So, Mr. Lee, you and your party don't have to worry that by having this sunset clause, the tough measures must be scrapped. I hope you understand why, and I hope after my explanation, you yourself and the DAB will vote for my amendment. It is not the government which makes a decision. It is the LegCo which makes a decision. So we can reach a consensus after thorough discussion so that we can fulfill our role as gatekeepers. So I urge members to support the Liberal Party's amendment. Mr. Dennis Kwok. Mr. Chairman, this is the third time I speak. Mr. Lee posed some questions, and I will try to explain to her and try to persuade her to change her views on my amendments. Now, I reiterated there are three rare features regarding this amendment. Or regarding this bill. First of all, it has a retrospective effect. In itself, it's very rare. In terms of subsidiary legislation, there could be retrospective effect, like the milk formula, baby formula milk ban. And in terms of principal legislation, it takes effect before it is scrutinized. And this is a second rare feature. It has retrospective effect, and it is a principal legislation. The third rare feature is that in the course of scrutinizing the bill, the administration originally stated that some would be granted exemption according to their policy objective. But now the policy objective has changed, their position have changed, so that originally some would not be affected by this piece of legislation, will now be subject to it. I don't believe these three rarities have ever existed. So will this create a precedent so that in future somebody will hold this blue bill and suggest that now that it has retrospective effect and we will be affected? I don't think this will happen because, like I said, for these three rare features, I don't want to see them happen again in the future. Because coming back to the point on uncertainty, as Mr. Lee puts it, she's also concerned about stability of the market. But by having these three rare features, you are allowing these uncertainties to continue, because the government could change the stance in such a manner so that those originally not affected by the bill will be affected. And we're not just looking at the blue bill, we need to look at the whole process. Throughout, the administration has told the public that exemptions will be granted to some. Although the administration has also emphasized that the bill has yet to be passed, and some might query that ultimately there is no idea whether the stamp duties will have to be paid, because maybe the bill can't pass all the three readings. So there is offsetting here. Some might take the risk and hope that the bill will not be passed eventually. Some might hope that the criteria for granting exemptions might be changed. But all in all, you have told some people that they will be exempted from the stamp duties, and then you changed your policy and you went back on your words so that these people are now required to pay stamp duties. And Mr. James Toh just quoted a very good example. Originally, some conduct might not be regarded as criminal, and yet after passing a piece of legislation with a retrospective effect, such past conduct will be regarded as criminal. If this were a piece of criminal legislation, this would, of course, be unconstitutional. And for this bill, it will have far-reaching implications. That is why we must not let this bill pass in such a manner. Otherwise, LegCo's functions will be greatly undermined, because we're here to prevent something like this from happening. when the bill was first introduced, it has already set an effective date then. And if policy can change, if the government's positions can change all of a sudden, so that some people originally not affected will be affected, then we must fulfill our electoral function. As to whether in the future somebody might rely on the blue bill and suggest that this is the law, I don't think so, because this is a rarity. Now, Mr. Chairman, just now, some members commented on the sunset clause, and the Civic Party would also like to express our view. When we talk about, for example, the surveillance and interception of communications ordinance, that is a different picture, because that piece of legislation was greatly flawed, and it has a huge impact on the fundamental rights of the people of Hong Kong. That is why we have asked the administration to include a sunset clause, so that after a period of time, the administration must review in depth the ordinance to minimize the harm done to our people, in particular the infringement on people's constitutional rights. It was under those circumstances that we proposed the sunset clause. The situation is different from the current sunset clause proposed, because we're talking about a form of taxation, and of course we must look at the background, which is market changes. Nobody can speculate or foresee how the market will change.
Now, in the other case, the desire for a sunset clause is to safeguard the human rights. So the two cases are very different. So I speak. Mr. Lam Tai-fai. Thank you, Mr. Chairman. This morning, you heard the representative of the legal sector, Dennis Kwok, representative from the accounting sector, Kenneth Leung, and you've also heard from Abraham Sheikh, representative of the real estate sector. Now, I am honest, I'm pragmatic, I'm realistic, I represent the industrial sector. I would like to analyze the issue from the point of view of a common person. I would like to look at the mentality of Hong Kong people, the values system of the Hong Kong people. On such a basis, I try to address the necessity of the sunset clause and whether it's something we all desire to have. Mr. Chairman, many Hong Kong people, including myself, spend at least 20, 30 years' time, not to mention whole life's time, to make a living, to try hard so as to get a roof over our head. A property purchase is the most important of all the important issues in one's life. For anybody talking about life planning, you can't avoid the issue of property purchase. And timing would also be important. Timetable is important. So you need to have a timetable to buy a property. You need to get a down payment, the mortgage repayment, monthly mortgage repayment, how much time you will spend on working as an employee or becoming a boss. Sometimes you have to spend your whole life before you can finish the repayment. Now, for this set of drastic demand-side management measures, the government's aim is to cool down the property market and give priority to Hong Kong people getting properties. Now, the market has become stagnant. Investors and speculators alike dare not enter the market to buy property because they don't want to have negative assets. The government has been threatening with enhancement of the SSD and the BSD. The draconian measures will become more draconian. The administration is an expert, is a self-professed expert. The administration is telling us that it is ahead of the market and can tell what the market will develop. But I think the government is being self-contradictory. We need a sunset clause. We need to plan for lives, and we must have our own timetable. Now, the government has been saying that this is supposed to be provisional. For how long would it remain temporary? Exceptional measures under exceptional circumstances. For how long? The administration has been arrogant. It seems that it can foretell when capital will flow into Hong Kong and when it will leave. For supply, of course, 470,000 in 10 years' time. And it seems to know when interest rates will go up or come down. Now, for demand and supply, the administration is telling us that it is in control of both sides of the equilibrium. But we don't know anything about that. When we want to buy a property, we want to know about our timetable. The property isn't just a roof over our head. It is also a way to move upwards socially. In Hong Kong, if you just rely on your income from your work, you can't catch up with inflation. So the property that we live in is usually regarded as a commodity. For a couple, we'll try to save a lot of money to buy a property of 300 to 400 square foot, and then if luck visits us, and then we may be able to have a bigger replacement property, and then our assets will grow in value. But we also need to plan for the timing of the replacing of our property. We can't just imagine what things will happen to us, and then we'll work hard for 3 or 4 years. So we need to have a timetable for everything. So we replace our properties, we move upwards socially. So timing is important. Timing is needed for everything. Mr. Chairman, you always remind us that we will have our meeting until 12 tonight and we'll resume at 9 o'clock. So there's a timetable for me. I know when to get up, when I have to work hard again. Mr. Chairman, the administration has been saying that the market fluctuations are difficult to tell, but they are in no way comparable to political changes. In politics, one day is too long. It is so volatile, and the changes are so numerous and so huge. Now, for the 5-step process in political reform, you also have a timetable, and then you have a 5-month consultation period, 5 steps to be taken, and then with universal suffrage for 2017. So in everybody's life, we need a timetable. If you don't have a timetable, then you are the night of a soul, and then you are just a walking dead. So I agree that for each strategy, for each policy, we need a timetable. It doesn't matter if the timetable is adjusted and revised from time to time in the light of market changes and if impacts of external market factors. It doesn't matter, but at least you need to show people what vision there is. Say, for example, if the draconian measures are so draconian that the market becomes stagnant, and then on the 26th of October 2015, it will expire, and then I can expect a change upwards by then, and then I don't have to work too hard. I don't need to get a second job. So I would rather settle for a PRH or wait for HOS unit. When you don't have a timetable, then people don't know what to do. They will just queue up. Now we have got 200,000 people on the waiting list for the PRH. 80,000 of them are non-elderly. They are young people under the age of 35. 40 or 50,000 of them are university graduates because they see no future. They have no hope. They don't know when the government will come up with a draconian measure and when they will withdraw it. Now you say that you want the youth to flourish, and you want the society to flourish. James Toh it's right to say that there isn't a timetable because this is to disguise the government's failure to increase the supply. This is to hide away the government's lack of strategies or response. So the government just wants to drag their feet and try to delude us for as long as it can. There are no transactions. The market stagnates. Now you can then tell us that there's no need to find more units for people because there isn't a demand, and then the PRHQ will grow in size 200, 300, 400, 500,000 on the queue. You won't care even if you have got one more added to the list, the waiting list. Is it that difficult to find land? Of course not. You have got a lot of land in the new territories. Just develop Northeast NT. It is a good approach, but you just got the wrong person to do it. You just got the wrong person to do the liaison work. So that the result is that Lai-wan has been agitated. Now, you should know which site is available, which site is negotiable. It is all clear. You just don't start a dialogue, release the potential of the land, quickly build more PRH units, more HOS flats, and then you don't have to rely on such measures. Now you are turning away the investors. They will go to Southeast Asia. Even if they go away from the market of Hong Kong, we can't solve our own problem. People of Hong Kong can still have no roof over their heads. The PRH waiting list is getting longer and longer. And then more and more people will lose heart. They will have no hope. For the sunset clause, we want the sun to set, right? Now, for the BSD, now Sterili says that she cannot understand. She doesn't understand. Well, it was first launched on the 26th of October 2012. So we are giving the administration 3 years' time to have it expired in 2015. You need 30 years. If we say 2 years, we will say why not 3 years or 1 year? We still have to plug a figure somehow. 3 years is more than reasonable. You can achieve a lot in 3 years' time. So I hope the administration will listen to us, other than the lawyers, the accountants, the real estate developers. Please also listen to someone like me who is pragmatic and realistic. Please do something to restore hope in us. Mr. Albert Chan. Thank you, Mr. Chairman. I did not intend to speak, but then as a result of what Mr. Abraham Sheck has said, I've been sort of stimulated, and I think it is thought-provoking. He said that he's a common man, and I think it is something that has provoked me to think and speak. From Mr. Abraham Sheck's status here, his identity here, I think instead of Captain America in the U.S. Parliament, now he is the Captain Hong Kong. He represents half of the assets in Hong Kong, so he's the spokesman for the super rich in Hong Kong. Over the past few days, I think Mr. Abraham Sheck has fully played his role as the representative, the spokesman of the super rich. I think he's trying to criticize the bill. The bill has been regarded as totally useless. Whatever he says, whatever he I will try to object. But when he says that he objects to something, we have to be careful, in particular if he objects to the government's view. Just now he talked about justice. Can it be more ironic for the justice of the miners buying properties? That's something which is very important. It is a justice that he has to defend. But what about our election rights? It has been stalled. We have been denied the right. Where is justice, Captain Hong Kong? So when I see this sort of standards from our lawmakers, for us to see such selective and biased values for us to see this distortion, for us to be given this sort of definition for justice? Well, in the eyes of the super rich, I think justice is being equated to the dollar sign. Anything that will affect the rich to make more money, then it is unjust. If you want to seek favor from the rich, is it justice? When you deny the electoral rights, is it justice? I think it's a matter of profit making. Now, for sunset clause, I think I can claim to be the lawmaker advocating the largest number of sunset clauses. Mr. Lam Tai-fai talked about sunset clauses. I talked a lot about it a year ago, but everybody voted against me, including the Civil Party. When we were filibustering, I proposed dozens of sunset clauses. All of them were vetoed. On this occasion, it is difficult for me to support the sunset clauses. In particular, they came from the Liberal Party. Now, let me look at the principles as well as the spirit. I think they are entirely right to suggest a sunset clause. Basically, the government has proposed the demand-side management measures as something extraordinary and is urgent to respond to the property market. The government would like to curb the rise of the property prices. It is not something to tackle the root of the problem. It is before we can increase housing supply, we need something administrative in nature, or we need something which is fiscal in nature to artificially and technically hold back the sentiments and force the prices to come down.
So for temporary urgent measures, in theory, there should be a sunset clause to set a time limit, 3 years, 5 years, because many housing units have yet to be built. Now, Dr. Lam Tai-fai said that Lai-wan is angry now, or I'm angry too. How come, site owned by the lease in Kutong, the whole area is zoned residential, and it falls perfectly in the map. As for the land owned by the Laos, it remains the green belt. Of course, you're bullying me. Well, the rural power should have come out. How come you just take care of the consortia, but you discriminate against rural land or land owned by the rural population? You're saying that because you attach to the land, so we will zone this green belt for you, for your good. Anyway, that's a separate issue. But I think the rural committee should be up in arms. Now, what I'm saying is that in terms of theory and logic, since this is an urgent measure, there should be a time limit. But the people powers analysis and assessment is that this two drastic measures should stay forever, because this is about defending the interests of local people. If you are not Hong Kongers coming to Hong Kong to buy properties, of course you should pay more in stamp duty. This is the protection you should afford to Hong Kong people. So in terms of policy, we want this policy to stay for good. That's why we are against the sunset clauses, because we want these measures to stay on. But of course, technically, perhaps for companies, there should be some other arrangement. Perhaps there could be some amendments in future after some time. That is for Hong Kong people-owned companies, say within a certain period they not sell the property. They do not sell the properties, then BSD could be refunded to them and whatever. I think we could make amendments later on such matters. Because as we said, we don't want this bill to be passed during the second reading debate. There are many ways to do it. One way is to vote against it during the third reading, or you could vote against the provisions. Another way is that there is not a quorum and the meeting and the bill will be aborted. Mr. Chairman, I call for a quorum.
陈伟业议员。
Mr. Albert Chan. Mr. Chairman, I don't quite follow. Many don't quite follow how come the people power says that we support the spirit of the legislation and then why resorting to various means to block the passage of the bill. Well, it's for a simple reason. There are a lot of problems still with the bill, especially the Secretary reached a private agreement with two major political parties that's gone against all legislative procedures and that's also distorted the original intention of the bill. That's why we would like this bill to go back to the Bills Committee. Now, on the arrangement agreed between the Secretary and the two major political parties in private, this should be spelled out in black and white in the bill. Now, if that means upward adjustment of the rates, it will be scrutiny before and for commencement. But if it's a reduction of the rates, it's negative vetting. Well, then you should include another clause in the bill to give play to this arrangement. That's the proper way to do it, because when it comes to lawmaking, there can be no private deals, as Mr. James Toh put it, that we are mainlandizing this sort of arrangement. Continental law is actually mainland law. When we talk about mainland China is about the Communist Party, it's the same. So you are actually making this law of making the law the mainland way. That's why it's not acceptable. Many members talk about the sunset clauses. The Secretary accepted the proposal of the two major political parties, the AB and BPA. And that's actually a hidden sunset clause. You don't know it? Well, Abraham Shank would know it because he represents the real estate factor. He knows it well. Others probably are kept in the dark. There is actually a sunset clause. That is, the Secretary said openly, this undertaking is made by this term of the government, so it remains valid in this term of the government.
However, there are uncertainties concerning this sunset clause because we don't know how long this term of administration will last. Maybe before 2017, this government could collapse any time. So in terms of a major policy and a major arrangement, how can we have such an uncertain factor in it? In particular, when this administration's popularity is at stake. Maybe the Communist Party will sack CY Leung. Maybe through this undertaking, this administration can extend its life. This will not be the wish of the Hong Kong people. And Dr. Lam Tai-fai to my left also hopes that this administration will collapse. Well, do some soul searching, Dr. Lam Tai-fai. Mr. Deputy, I asked that his remarks on me be withdrawn because it's important. This is just a conjecture. I can't make some conjecture and speculate what other members think. Please withdraw your remarks. Yes, this is what I would say in my dreams, so I withdraw those remarks. Dr. Lam Tai-fai, he has continued to fabricate against me. I support the SAR government in governing Hong Kong in accordance with the laws. Well, I emphasize that Dr. Lam Tai-fai says he supports this administration, but not the chief executive. That's what he said clearly. Coming back to the implied sunset clause. Throughout the years in LegCo, we've never seen an implied sunset clause. And this implied sunset clause is legally binding. How should it be pronounced? Implied, implicit? Mr. Leung Kwok-hung tried to incite me to say something vulgar. Well, this implied sunset clause is a serious matter, and it is also a distortion of our legal procedures. and the legislative procedure. How can you, through agreement between the government and political parties, give an undertaking instead of making express stipulations in written form, apart from having it recorded in the Legico's Hansard? Other people, on reading the legislation concerning the tough measures, they will be looking at the stamp duty amendment ordinance instead of reading the Secretary's undertaking and his agreement with the two major political parties anywhere, because it's not written. In several months' time after the bill is passed, if a solicitor is to offer advice to clients, if a decision has to be made, they will rely on the ordinance. Unless they have been following this debate and following the scrutiny of the bill, they wouldn't know such an implied sunset clause. For foreign solicitors and foreigners who have not been paying attention to the scrutiny of the bill, they would have no idea about this legally binding implied sunset clause. By reason, this bill should go back to the Bills Committee for further scrutiny on this agreement, which has come by behind closed doors. The bill should go back to the Bills Committee so that the Bills Committee can maintain its dignity and we can do justice to the general public, because the general public doesn't have any idea of this implied clause, and in future, because of the lack of knowledge, their rights may be infringed upon. It is important that we scrutinize the bill openly, because any provision which have binding effect, any provision that regulates conduct must be explicitly and expressly stipulated in writing. So, if a sunset clause is necessary, the agreement reached between the Secretary and the major political parties should also be included. I want to point out that the C.Y. Leung has the conspiracy to cause the property market to collapse, because when property market is in chaos, the mainland-backed investors will invest in the property market and drive foreign investors away. So for DAB-backed investors and other people, they can also intrude, so to speak, the property market, and it will be tinted red in the future. The property market will be invaded, so to speak, by mainland investors. Mr. Tony Chair. Thank you, Mr. Deputy. I have to declare, first of all, that I own properties and I have a consultancy firm which also owns properties. The tough measures serve to fulfill its purpose during exceptional circumstances of the property market. Just like during SARS outbreak, there could be side effects by taking some medication, but without other better alternatives, these measures must be implemented. Now we're in severe shortage in terms of housing supply. The previous term of administration has not set a housing production target or made any planning. Although in recent years the administration has decided to increase land supply and increase residential housing supply in the private and public sector, we still cannot address the problem in the short term. With abundant liquidity and low interest rates and tight housing supply, speculative activities continued and property prices have soared beyond the level affordable by ordinary people. As a result, the administration has introduced demand-side management measures to suppress the overheated property market and to curb the irrational soaring of property prices. This is an extraordinary measure during exceptional circumstances for the purpose of cooling down the property market. This, although may have certain impact on the free market principles upheld in Hong Kong for a long time, it is necessary. And on whether sunset clause should be introduced, I think we should consider the clause very thoroughly. Ever since the introduction of the tough measures, we no longer see the continuous soaring of property prices. At the same time, we see the market becoming stagnant with low transaction volume. Unless with urgent needs, buyers will not buy properties at this moment, because when property prices are still high and with futures being uncertain, they don't want to enter the market casually. And we have also seen speculative activities being curbed, leading to a drastic drop in the number of transactions in the market. Apart from buyers, in terms of sellers, since supply will still be tight in the near future and interest rates at the moment is still low, with abundant liquidity in the market, sellers would not be too pessimistic about the market's prospect, and there is no need, therefore, for them to cut prices to sell the flats. So, as they're not anxious in selling their flats and buyers are not in a rush to buy flats, both are just observing the market, causing the transactions to drop in number. Therefore, I think it is our responsibility to finish scrutinizing the bill as soon as possible, so that the market can carry on with its activities with clear circumstances. According to statistics, in terms of number of property transactions, as of January 2013, it has dropped from 8,360 in January 2013 to December 2013, just 6,000. In terms of private property transactions, it has dropped from 4,399 in January 2013 down to 2,429 in December 2013, a drop of 45%. Is the decline solely because of the tough measures or other factors? I believe we all have an idea. However, in terms of the number of transactions, the volume fluctuates depending on how the buyers and sellers think of the market's prospect. And there are also other factors to consider. For example, whether the interest rates will change, and also the abundance of liquidity in the market, and also the government's policy on the property market. And last year, the legislation regulating the first-hand sale of properties or residential properties could also be one of the factors affecting the supply of residential properties in the market. In fact, according to statistics, after the relevant piece of legislation took effect in April last year, the number of transactions have dropped, and in June 2013, only 106 transactions have been recorded. Just 1/10 of the number of transactions in the same period last year, or in the previous year. Had the administration not introduced the tough measures, if this Stamp Duty Amendment Bill 2012 is not passed, then with low interest rate and tight supply in the property market and relatively abundant capital in the market, there could be undesirable stimulations and speculations, so that short-term speculative activities will revive, and the upward trend of property prices have somewhat tapered, and in fact, it's starting to be on a decline. And yet, if the bill is not passed, prices may continue to rise and I am confident, I'm sure, that probably property prices will rocket and buyers will stand to suffer. I think we have to consider carefully these consequences.
Also, after all, this bill is not the be-all and end-all. Even if it is carried, I still hope that the administration can expedite to add resources and manpower, especially civil servants, to complement the production of housing stock so as to supply adequate housing to the market. Mr. Chairman, taking short-term extraordinary measures to tackle exceptional times is good for the public and the market, but the curbing measures must be clear-cut. That's very important. Now, when should there be an upward adjustment, when a downward adjustment, and when should the measures be withdrawn? One of the objectives of taking these measures is to further suppress speculation and short-term transaction changes. The measures have been with us for some time now. We are starting to see that when developers launch new projects, in order to attract buyers, they are offering different kinds of discounts and concessions. In the Eastern District, there is a new residential development where the developer has allowed a closing period of 270 days. And then there are all other discounts and concessions amounting to a total of 20% of the property price. So the measures have an impact on the market as well as developers. Many people are concerned when the measures will be withdrawn or when the tax rates are to be reduced. So the Bills Committee eventually agrees with members that we should ask the administration to include a sunset clause in the bill. When I started to speak, I support and agree that extraordinary measures should be taken for exceptional times. But I am also of the view that the administration should set down objective factors for withdrawing the measures. For example, at what time, with what circumstances will you consider triggering the withdrawal mechanism? I believe such factors would include, to a certain extent, the property prices have fallen, and to a certain extent of housing supply, and also rise of interest rate to a certain level, and the vacancy rate, and also the level transaction numbers should drop to, etc. The administration should send a clear message to the public and the market so we are psychologically prepared and we know what to do and how to make plans. Secretary, I really hope that you will give us a very clear reply on this one. Mr. Chairman, as to the amendment to include a sunset clause in the bill to set down a clear-cut date for withdrawing of the measures, I think that is not appropriate because no one knows and no one can predict with any accuracy when there will be changes in the market. Should it be the end of this year? Should it be the end of next year? When will be the most appropriate time? In any case, if the administration does not consider setting some sunset conditions for measures withdrawal, I am very disappointed. Thank you, Chairman. Mr. Ibrahim Sheikh. Mr. Chairman, with regard to Mr. Dennis Kwok's amendment, after listening to his remarks, he supports the amendment to be moved by the administration. But when we are in this most difficult period because the administration has cheated people of the time, I think even if the administration is taking a wrong step, we still support Mr. Dennis Kwok because I think he is rectifying a wrong. So we will vote in support of you. I believe those who have trusted the administration and have bought property, now they can resurrect. Now, I don't know whether I should thank Mr. Albert Chan because he quite sympathetically criticized me. He did not call me any names as he did to officials. I think he is a little compassionate towards me. But he has also called me a Captain Hong Kong, a new name that he has given me. Should I also return his goodwill and call him Captain Vancouver? Why? This is because he is in Hong Kong, but his heart is in Vancouver. He wants to introduce chaos into the Hong Kong market. So he shouts and says what he likes to say. We are debating the sunset clause. He says the Liberal Party has good logic. There should be a sunset clause. But then suddenly he said he did not follow his logic. He said what the administration says has a latent effect similar to a sunset clause. What is he talking about? Yesterday, he voted against the formal undertaking of the administration, but today he says there is this latent effect. And then he says that Mr. James Tian is saying that we are trying to mainlandize Hong Kong. But in Article 5 of the Basic Law, national policies will not come to Hong Kong, but Hong Kong will remain a capitalist society for 50 years. So what is he talking about? He is trying to bring in class struggle in Hong Kong so that Hong Kong will become socialist as they like it. Well, it's all right for him to say what he wants to say, but he lacks logic. And he says, Abraham, you represent the developers, so you have no right to talk about justice. But everybody should have justice, the rich or the not so rich. He has money to buy property in Vancouver, and he can do whatever he wants to do. But why can't businessmen do what they want to do? He says he supports the spirit of the administration that Hong Kong people should be able to buy Hong Kong property. We are in that category as well. It is just that we don't want Hong Kong PR companies not be able to buy property. So he has no logic. He just shouts. Whatever Abraham says, he will object. And if you look at the voting sheet, he actually supported my amendment yesterday. So it's quite laughable. it seems his brain and his mouth are not working together. Mr. Chairman, when he speaks outside the chamber, he is more logical. He would say all businessmen are bad, but sometimes he have meals with businessmen. He talks to them. So practice what you preach. Everyone has that right, and regardless of whether you are rich. Article 25 of the Basic Law, Mr. Albert Chan, you are not here. It says all Hong Kong residents shall be equal before the law. Article 5, we are a capitalist society. This is also very clear. Captain Vancouver, who is a member of Quality, however, he dares criticize other people here. It's all right for him to criticize other people. Well, he says, I am petty, but I represent the developers all right. I also did not say I want to do what you, Mr. Albert Chan, does. If you support my amendment, I think it's also laughable, because sometimes I can also agree to what he says. And I don't think he is totally bad. He wants to get votes, but that is not the way to do it. We are fighting for that right for minors. Never mind whether they buy property. Give them that right. But then they say, no, developers' representative should not be saying this because he doesn't have the position to say this. But he himself bought property in the name of a company together with Yuk-man, and then after a few years, he sold it off. Did he involve in speculation? Why would he have that right and other people don't? Many members hold property in the name of companies, Mr. Secretary. And yet, you object to Hong Kong PR companies hold properties. I think there is a conflict of interest if you object to my amendment. Other people cannot buy property in the name of Hong Kong PR companies unless they pay 15%. But now, they themselves hold property in the name of a company, and they can sell the company so they get 15% more profit. Is there a conflict of interest? Mr. James Toh holds a company, and some other members confirmed that. So let us be fair. Rights and justice are for everyone. Rights are given to us in the Basic Law. Now, let me come back to the Sunset Clause. Now I would talk about the Sunset Clause. I haven't even started to talk about it. Even if I don't have enough time, I will speak again. Maybe I shouldn't take up more time now. Mr. James Teen. Mr. Chairman, Mr. Ibrahim Sheikh, you need not be too worked up. If you are agitated, you can well get agitated every day. Well, there is this article in Singtao Ribao saying that James Teen is standing in the way of the bill, but compliments Mr. Ibrahim Sheikh, saying on behalf of developers that delay will do no good. I think Mr. Anthony Cheung is not responding to us here in the chamber, but I think this has been written by the CE's office. The writer is called Kem Chung Yet, and it says quite well, and I don't even have to declare interest. Mr. Ibrahim Sheikh represents the large developers, and then they say, I am a medium-sized developer, so what I'm doing would be benefiting Mr. Ibrahim Sheikh. But if I am just a small developer, I need not declare interest. Is that right? Because I'm so small. Mr. Chairman, about this Sunset Clause, we have met many people from the middle class and estate agents. And the middle class stands to lose the most because of these measures. Also, estate agents who also belong to the middle class. I am a small-sized developer, all right, but I am aware that the operation of large developers is more or less like ours. It's just that it's 10 times bigger than us. And we like to make this metaphor. It's like baking bread. If you are in the developer's business, you buy the flour and you bake it, then you get a roll. However, a roll can be prepared within 1 or 2 days. However, the developer buys a site and you need to spend 5 years before you can put up a building. That period can see a lot of fluctuations in prices. Now, as Mr. Tony Jie is saying, land prices have fallen. Well, yes, of course. I know how to do the sums. If I sell cheaply, then I can also get a site even more cheaply. There will be a tender soon, and you can buy the sites for $5,000, $6,000 for each foot. And in Tseung Kwan O, the prices have fallen to like 3,000 to 4,000 dollars per square foot. Of course, construction prices have gone up. However, using this logic, for large developers represented by Mr. Ibrahim Sheikh and medium-sized developers, they think it's all right, even if you have these measures. If the sites are sold for a high price, then I sell also at a higher price. And then if the site is cheaper, then I can sell the units cheaper as well. So I don't think the developers have made a bigger or a lesser profit.
No, it's true that with the demand management measures, the sales volume drops, but then developers are now able to buy sites at a lower price. But then those who suffer most, those who are most victimized, are the general public. According to the government statistics, about 90% of the flats are in the hands of owners and landlords. Only 10% are with the developers. And you know, there is there are very little, there are very few transactions in the secondary market. You know, the longer the holding period, the lower the SSD, and then for outside buyers, they have to pay 15% BSD. And so many in the middle class have complained to the Liberal Party. They are of the view that these measures, the government's measures, will not hurt the developers. But then, no, there are very few transactions in the secondary market. The landlords suffer, the estate agents suffer. And you know, estate agents also rely on the sale of first-hand flats by developers, because usually developers launch 200 to 300 flats in one batch. So we can see that the volume of transactions has dropped by 80%, but flat prices haven't dropped by 80%. But of course, I don't think the administration would like to see flat prices drop by 80%. But then we can see that the volume of transactions has dropped by 80%. Now, you know that when the demand management measures were launched, the government said that it wanted to see people who were unable to afford to buy their own homes becoming able to buy homes. But then, you know, why? But what has happened? The volume of transactions has dropped. Landlords are unwilling to lower the prices in order to sell their flats quickly. And we still have a lot of people who didn't have flats 2 years ago, and they still can't buy flats today. Now, concerning this idea of a sunset clause, Mr. Anthony Cheung once said that for sites auctioned last year, this year, then the flats will be available in 5 to 6 years' time. There will be adequate supply, and so prices will not go wild. Now, so you are saying that there is a policy to put more sites up for auction in this year and next year, and as a result, there will be 20,000 flats in the private sector per year a few years later, and then several tens of thousands of public sector flats. So if you don't want the sunset date, so to speak, to be 2 years, then what about 5 years? I believe you do have a date in mind, and in your mind, what price levels are reasonable? So you may think in an urban area, the price of 20,000 square foot is excessive. So what is the reasonable price level in your mind? $10,000? Tell the public. Tell the public that you withdraw these measures. If the price per square foot in the urban area is 10,000. Now, the administration can't give this figure because sites are put up for auction, and I think everybody feels that the site should be awarded to the highest bid. So the system has to be fair and transparent. We can no longer adopt a system which was practiced in the mainland some years ago. You just tell in other words, the privileged people will get the sites. So, but say if now at the moment, for example, next week there will be the auctioning of the sites in Kai Tak. So you of course choose the highest bid, right? I don't think you will say, all right, let me choose the lowest bid so that the flats to be produced in the coming years will be cheap. And if the flour is expensive, how can you expect the bread to be cheap? And judging from the present land price for urban sites, and if we also take into account inflation, I don't think it's really excessive if the flat prices or the price per square foot reaches 20,000. So I really don't think in the urban area there will be many flats in the years to come with a per square foot price of $10,000. So you choose the highest bid when you auction sites, and so it won't be, say, $2,000 or $3,000 per square foot in the urban area, right, for a site. And then for the middle class who want to change flats, and they suffer a great deal. They have to pay the SSD, and then they have to outside buyers may not be interested in our flats because they have to pay a BSD. And then I want to say that we have seen a rise in the number of mainland tourists to Hong Kong. Hong Kong people are unhappy. Many tourists are also unhappy. So should we set a cap? People are asking this question. Should we set a cap for the number of tourists to Hong Kong? Now, this article that I've referred to, written by the so-called person in Admiralty, and I guess that this person is from the CE's office. And I think if society is so divided, that will not be good. The central authorities want harmony. Now, in fact, many provinces and municipalities in the mainland are of the view that Hong Kong has got a lot of favor from the central authorities. Many tourists are coming to spend money, and then there's so many concessionary arrangements under CEPA. And Hong Kong people feel so aggrieved. Hong Kong people have said that they do not welcome mainland tourists. So mainland tourists may feel that they are being discriminated against. And once there are ill feelings, it will be difficult to change or reverse such ill feelings. And if mainland tourists do not come to Hong Kong, then their money will be absorbed by other places, other countries. Now in Hong Kong, we have the 15% BSD. And do you know that if we look at flat sales in London and New York, you see that there are a lot of mainlanders who are interested in those flats. And even sometimes when we express interest in flats in major cities overseas, and when we express an interest, and then in the course of the negotiations, the mainland investors or buyers will decide to buy the flats. I understand that London welcomes the mainland investors, New York welcomes them, but then in Vancouver, I understand that they are beginning to stop the influx, so to speak, of mainland investors. So, but then in Hong Kong, under one country, two systems, we have to be very careful in handling our relationship with the mainland. Now, if one country, two systems begins to develop in this direction, that will not be good for Hong Kong. Hong Kong people keep emphasizing two systems. We don't have any pan-democrats here. They emphasize two systems. Hong Kong people feel unhappy because mainland people come to buy powder formula flats and so on and so forth. But we on the side want to emphasize one country. Now, I understand that in Beijing, in Shanghai, they also have extraordinary measures to curb property speculation. But the central government and the municipal governments have confidence. They know that the extraordinary measures will be withdrawn, say in a few years' time. But in Hong Kong, can our government have this confidence? Can our government say when the measures can be withdrawn? But then 14 years have already, I beg your pardon, 14 months have already lapsed. So, when should the sunset date be? The administration has made a concession. He has given the verbal undertaking. So he is saying that there's no need for a sunset clause. If I want to reduce the rates, then I can do so, say 1 year or 9 months later, or 2.5 years later. I don't need to put in a sunset clause, say 2 years. And I want to go on. But I want to say that this approach adopted by the administration causes uncertainties in the market. There is no sunset clause, so people are speculating when the administration will reduce the rates. We want to hear some good news from the administration that the rates can be reduced tomorrow. Mr. Lo Wai-kwok, thank you. As I said earlier, Chairman, when we discuss the various amendments, we need to take into account the legal principles, and we have to be reasonable. These exceptional measures are needed for extraordinary times and circumstances. But then we shouldn't have extraordinary measures lasting for an ordinarily long period of time. We don't want to see over-regulation of the market by the government. So I understand that the intention is to help Hong Kong people purchase their own homes, but I'm just worried that if the measures go on for too long, then there will be adverse impact or adverse effects on society. And so I think at least there should be indicators made known to the public as to under what circumstances the rates will be cut or even withdrawn. But then, according to the administration, the market is very sophisticated, complex, and volatile. it's difficult to come up with indicators. But then in the U.S., they have announced very transparently the indicators for the tapering of the QE exercise. Mr. Andrew Leung proposes that on the 26th of October 2015, the measures or the demand management measures will lapse. I think we should support this amendment because that would mean that before the deadline, there will be a comprehensive review of the property market, and then appropriate policy measures can be adopted accordingly. But then Mr. Anthony Cheung may say, oh, a sunset clause will send the wrong message to the market. People will think that the administration is not committed to curbing property prices and speculation. But then I want to say this, and that is there are various amendments proposed by members. The members want to perfect the demand management measures put forward by the administration. Mr. Abraham Shek is of the view that for Hong Kong PR companies, although they need to pay the tax upfront, the tax can be refunded to the companies at a later stage. But then the administration is of the view that would reduce the effectiveness of the demand management measures. The administration does not accept any of these proposals put forward by members. So it seems that this administration is like the previous administrations. It is just going step by step. It lacks long-term planning, and it keeps on going back on its promises.
At that time, Mr. Tung Chee-hwa did earn some applauses. But then in 1998, we had the Asian financial turmoil. The economy experienced a downturn and property prices dropped tremendously. Many people suffered from negative assets. In about 2006, I asked whether or not the production objective of 85,000 flats per year would be modified. And then we were told that as this 85,000 flats had not been mentioned anymore, it no longer existed. And that's actually become a laughing stock. That is, if you don't mention something, it's gone. In the middle of 2003, negative asset mortgages amounted to 22% of the overall number of mortgage loans. And because of a collapse in the capital chain, many people suffered tremendously. In 2008, there was this financial turmoil, and then HOS was suspended, and Hong Kong Peninsula was sold at a very cheap price. Members of the public became more and more dissatisfied. Mr. Donald Tsang, the former CE, insisted not to revive the HOS. Therefore, the revolving door between PRH and HOS will become a lame revolving door. And later, Mr. Donald Tsang had no choice but to revive the HOS. Now, the history of the housing policy in the past 10-odd years proved that the government's policies are lagging behind time. And very often the government introduced new measures when the market experienced a turn. If the governing team does not want to, at the time of an economic downturn and a downturn of the property market, should manage risks and expectations well. Mr. Chairman, ever since the year 2000, global economy has suffered a lot of ups and downs. There's a great deal of volatility in the market. In 2008, the financial tsunami affected all economies in the world. In 2001, the European debt crisis started, and this year the U.S. says QE measures tapered off, and very likely interest rates will go up again. Therefore, to manage risks and expectations well is even more important. Risk and expectation management is an effective way to manage our property market. As for Mr. Dennis Kwok's amendment, that is between the 27th of October 2012 and the passage and gazetto of this bill, there should be exemption for minor Hong Kong PRs. Well, I think that's sending an opposite message. Therefore, for the sake of the principle of fairness, it is worthwhile to support Mr. Dennis Kwok's amendment. Mr. Chairman, the present SARJ has tried to increase the supply of land sites and housing units in order to address the serious imbalance between supply and demand. That's the right prescription. The government now would like to rely on this bill to curb the speculation in the property market so as to cool down the property market. In the past couple of days, there were heated debates in this council on the bill. Probably, members are unable to understand all the details in the bill, including the contents of the amendments. In the whole process, even our own members were confused. Therefore, some people criticized us for not knowing what we are arguing about, and those who have some understanding of the bill asked why we should be arguing. In fact, we would like to work hard for the sake of the healthy development of the property market. But of course, when compared with this bill, in terms of boosting land and housing supply, the government and the public must work even harder to forge consensus so as to attain proper balance and to give and take properly. That will be conducive to the housing interests of the whole public. Mr. Abraham Sheikh.
The CSA introduced by BPA Kwan-yuen and the Liberal parties before this council at this moment under debate, I give my support. The Honourable Andrew Leung's CSA proposes that the SSD and BSD lapse by midnight of 26 October 2015. That is coincide with the bills for the SSD and the BSD. While the Honourable Jones CSA proposed that the SSD and BSD lapse by midnight December 2014. I would support either of these two amendments, as a sunset clause can serve as an effective instrument to compel the government to act on its duty to review the BSD regime before the sunset date, as you have tried to do it through your oral commitment on the increase of the measures or the withdrawal of the measures. As always, Mr. Acting President, the administration's perpetual explanation is that it is impossible for the government to predict future market changes. Nobody can. And various external factors, and to choose a date when demand-side management measures would no longer be required. Therefore, it argues that any prescribed sunset clause would only send wrong messages to the market and fuel demand, thus undermining the effectiveness of the measures. The effectiveness of the measures take precedence over everything, even the rights of individuals. However, this is a specious argument, seems to be right, but in actual fact wrong. Where the BSD, SSD, and DSD are concerned, the government always deceives the public, unfortunately. When the government introduced the SSD in November 2010, the first SSD, the then administration stated that The SSD was an extraordinary measure for the then extraordinary circumstances in Hong Kong to address short-term speculation in residential units. I supported that bill. And my CSA, the sunset clause to the Stamp Duty Amendment Bill of 2010, was voted down when the majority of this Council, with the pro-establishment vote, was deceived by the government. By the same token, the administration pledged in the SSD in the Stamp Duty Bill in 2010 to review the SSD once every 24 months or earlier after the enactment of the bill, or as circumstances required. However, 3 years have passed, and this review has proved to be no more than an exercise or gesture. The SSD has already becoming a standing stamp duty instead of a special stamp duty. Then the incumbent administration told the same, I wouldn't say lie, told the same excuse to the people when it introduced the BSD in October 2012 and the DSD in February 2013. The distressing reality is that there is no end in sight to the SSD, the BSD, and the DSD, given the likelihood of boosting flat supply, as pledged by the Chief Executive, is bleak in the next 5 years. At this rate, it is likely that the so-called extraordinary measures for exceptional times will last forever. It will be, as I said earlier, a standing stamp duty. Now that the administration has again undertaken to review and report to LegCo 1 year after the enactment of the 2012 bill, I hope that we can do it today, should we trust the government's word again and again, Mr. Acting President? When the finite becomes the infinite, the extraordinary will become the ordinary. If we allow this to happen again with the BSD regime, it will fly in the face of the objective of imposing tough measures on the property market on a temporary basis. This was supported by Kenneth Leung. If we're going to make this a permanent feature, might as well, the negative vetting has no place. It must be a positive vetting. While the administration is pointing the finger at the sunset clause for the possible confusion it would bring to the property market, the administration ought to do some soul-searching. Who was the first to disseminate erroneous messages to the market and distort market behavior by saying that the measures are temporary? It was unquestionably the government itself. In this context, a sunset clause is necessary to provide a mechanism to put things right, to put things back on the right track by obliging the government to halt its intervention after a sufficiently long period. Furthermore, a sunset clause will provide the government with a timetable to conduct a genuine review of the effectiveness of the BSD, SSD, and DSD and report the results back to the LegCo. This is what our friend in the opposition camp was asking for. Without such a mechanism, there is no guarantee that the administration will undertake any of these commitments, much as we trust you and much as they distrust you. Mr. Acting President, I strongly disagree with the administration claims that the sunset clauses proposed by your good self and the Honourable Tommy Cheung are beyond the scope of Stamp Duty Amendment Bill. In fact, I would like to remind the administration that I also proposed a sunset clause be incorporated in the provision relating to the SSD in the Stamp Duty Amendment Ordinance 2010 Bill, and in sections 29CA, 29DA, and Head 1, Bracket 1AA, and Head 1, Bracket 1B in the first schedule of that bill. However, this proposal was not accepted, and therefore no sunset clause is included in the current Stamp Duty Ordinance. Mr. President. According to the Electoral Secretariat's legal advisers for the Bills Committee on Stamp Duty Amendment Bill 2012, it is crystal clear that the sunset clause is within the scope of the bill. It has no bearing on Part 1 of the bill, where the existing SSD regime is given effect. It is consistent with the long title of the bill, and it won't terminate the current SSD regime. The special stamp duty, or the always standing stamp duty, SSD, is charged under the head 1(1)AA and 1(1)B of the first schedule of the Stamp Duty Ordinance, Cap 117. The bill proposed to amend by Clause 18 the head 1(1)AA and 1(b) to increase the rates of the stamp duty on certain agreement for sale and conveyance on sale of residential properties that are acquired after 27 October 2012 and disposed within 6 months, 12 months, and 36 months to 20%, 15%, and 10% respectively. This is effected by adding a Part 2 to head 1(1)AA and 1(b) respectively. The existing SSD regime will become Part 1 and have effect only in the respect of residential properties acquired on or after 20th November 2010, but before 27th October 2012. The sunset clauses have no effect on such amendments. They also do not affect the effectiveness of the provision during the first period.
喺第一個時期呢，當我哋係開始額外印花稅嘅時候呢，就只係限制喺第一期。咁日落條款呢，就會令到條例草案增加嘅條文呢，就會
29CA and Section 29DA cease to have effect after the stipulated expiry dates. They only affect residential properties acquired after the respective expiry dates. Sorry, I have to be a little technical, Mr. President, because I expect the government to answer on this particular aspect. In the premises, the sunset clauses have no retrospective effect and could not be said to have negated the existing provision imposing SSD or the enhancement provision proposed in the bill. When it comes to the long title of the bill, Mr. Secretary, the legal advisers states that the sunset clauses are not inconsistent with the long title of the bill. The sunset clauses do not affect the operation of the provisions imposing SSD, but only restricting the application of these provisions in time. The long title does not state the time during which the SSD regime must remain valid. There is no presumption that the provisions of any bill must remain in force indefinitely, and their application could not be restricted in time. The sunset clauses do not have the effect of terminating the existing SSD regime if the proposed enhanced regime is not passed. Moreover, each of the sunset clauses have built-in provisions to allow the expiry date to be amended so that the SSD provision may be continued after the stated expiry date. Repudiating the administration's misconceived argument in the 11th hour about the effect of terminating the current SSD regime by the use of sunset clauses if the proposed amendment to the bill in relation to the SSD are not passed. Our legal advisers further highlights the fact is that the proposed amendments in the bill have imposed a date limiting the operation of the current SSD regime up to and include 26 October 2012 and simultaneously propose an enhanced regime to have effect from 27 October 2012. The sunset clause proposed no more than an end for the SSD regime. It is within scope for the administration to impose an end date for the existing regime. It is equally within the scope for the members to propose a CSA to impose a different date. Mr. Acting President, our President have won kudos for his impartial ruling based on sound reasons and solid legal basis. In contrast, the administration rigid and unbending attitude in thwarting the legislative attempt to move the sunset clause until the last minute demonstrate its overbearing attempt to undermine the legitimate power of this legislature, as evidenced by its letter dated 11 February to the Legislative Secretary before the deadline for submitting CSA to the bill. This is very rarely being done. As the legal advisers comment, if the administration's arguments is allowed to stand, it would practically mean that the administration could introduce amendments to the existing provisions. Members are not allowed to propose CSA in respect of provisions amended by the administration. That would have an effect on changing such provision unless that change is in accord with the administration proposal. This is unacceptable. Obviously, there is a point in the administration trying to inhibit the LegCo from moving the sunset clause. This was certainly an act of sabotage on a well-established separation of powers, the keystone of one country, two systems, which is set in stone under the basic law. There is a Chinese saying, a straw shows which way the winds blow. The degeneration of the relationship between the executive administration and the Legislative Council is evident. Mr. Acting President, as the old saying goes, fool me once, shame on you. Fool me twice, shame on me. You can't pull this over us again. Thank you.
Mr. Paul Chair, Mr. Deputy, I'd like to speak at this stage to say that I would support Mr. Dennis Kwok's amendment and also Ms. Starry Lee's amendment made on behalf of the Bills Committee. In the order paper, we should vote on Mr. Dennis Kwok's amendment first, but because of the importance of the considerations, let me now talk about the sunset clause first. Many members said why we will need the sunset clause. To a certain extent, there should be check and balance, so we can monitor the workings of the administration, especially with regard to unpopular or less than general provisions. We would like the administration to act fast so as to tackle mischief. We hope there will be policies to tackle these ASAP. I don't need to say more on this point, but all along I subscribe to the free market concept. Mr. Deputy, you always say we should protect the or safeguard the interests of the business and the rich. But then we must safeguard the system of the free market in Hong Kong, regardless of your class in society or your background. All along, Hong Kong has been a free market. Therefore, if there are any policies that would detract from these principles, we should act with caution. And this time around, this particular bill does damage the free economy principle that we embrace in Hong Kong. Some members said that we do not actually have any sunset clause in our laws. That's true, because we have always had a strong administration. The colonial government, of course, did not do it, but after 1997, we have an executive-led, or there is even executive hegemony in our administration, and therefore we are not following the developments in democratic societies. But if you look at the UK system, which we love to compare ourselves to, they have at least 2 or 3 sunset clauses passed every year. And if there are regulatory provisions on the business community, very often they would take the initiative to consider whether there should be a sunset clause so that the intervention into the operation of the business community would be brought up for regular review, or, as I said, that they should become invalid automatically unless the relevant provisions are passed again. This is not something strange or abnormal. On the contrary, this is quite common for the business world. Mr. Deputy, let us talk about taxation. Because of the nature of taxation, it means that the public's wealth or money have been mandatorily charged for the sake of infrastructure, for society's other initiatives. So every year we study the budget carefully, and every year we deliberately look at the taxation proposals very carefully. It's just like Girl Guides and Boy Scouts taking their oath every year after the annual parade. So this is not a new restriction. It should be done. Mr. Deputy, we are not talking about any special events in the market, for example, in the stock market, a plunge or something. We are just talking about a sunset clause providing for a date, and it is very common. And I also like to say that just now some members mentioned the basic law. As I said last time, the basic law is a constitutional document. It is an important document. However, it is couched in general terms. Everybody says the basic law safeguards this or safeguards that, but when a case is taken to the court, for example, the court of first instance may decide on a position, and then the appeal court may decide on the same position, and then at the CFA, everything could be overturned, and the administration should have learned those lessons, because the basic law is about principles, and it depends on what judges or justices at the CFA interpret these values. It is correct for Chinese people to say that judges can, in fact, depend on their value system and their judgment to identify the relevant clauses or articles in the law or the constitution to justify their judgment. So this is controversial. And in Hong Kong, this is particularly so. Why? Because there are many restrictions on the Legislative Council, and we cannot legislate after a judgment is reached by the CFA, whether to overthrow it, to vary it, or to minimize the effect of CFA judgments. In other countries or places, they have the right. But then the basic law does not allow us that power, and so we cannot legislate to amend or vary any judgments at the courts. So the harm may be bigger if the judgments are not accepted by society. Anyway, let us be realistic. We have to be careful and refer to the basic law. Just now I said those are in general terms, and we can only guess what they are saying. But if there are more articles involved, we should all the more be careful whether our proposals here would contravene the basic law. And if there is a big controversy, we should exercise particular caution. And when I spoke last time, I already said that at least 7 articles of the basic law are involved in this amendment, and I won't repeat that. But I'd like to speak on a particular one which is very crucial and important, and that is under general principles or the preamble. And there are other articles under it. For example, Article 1, sovereignty, and then self-rule, and then protection of Hong Kong people's rights, Article 6, ownership of private property, Article 8, that we use the common law. All these are most important fundamental provisions. And Article 5, I believe, cannot be found anywhere else in any other constitutions. And it says that the socialist system and policies shall not be practiced in Hong Kong as they are, and the previous capitalist system and way of life shall remain unchanged. This is a fundamental article. If it is challenged, we need to be very careful indeed. Why is it that it seems we don't really take it seriously and try to understand whether our policies are going against this article? I think the most important reason is that litigation fees are high in Hong Kong. Unless you are supported by CSSA, or else you dare not challenge the administration on the basic law lightly. And Article 5, for those who are supported by legal aid, they might not want to refer to it. On the contrary, the business community, professionals, and like myself, who place emphasis on the free market economy, would refer to this because we think it is important. But as I said, litigation fees are high and the risk is high, and this article also provides a lot of room for interpretation. So we should not refer to it as a foundation for staging a challenge. However, this doesn't mean that if any amendments, any policies are to comply with Article 5, that we should not exercise particular caution.
呢一個政策本身，雖然好多同事支持話一個緊急嘅政策，當然某程度都係啱嘅。但係
I understand that many members support this policy as an extraordinary measure needed in extraordinary times. But then should we, because of this special situation, brush aside Article 5 of the Basic Law? We have very important principles laid out in the Basic Law. We must have a low-tax regime. We must maintain Hong Kong's position as an international financial center. And so we need to scrutinize this present policy very, very carefully. We should look at whether certain aspects of this policy constitute a blatant violation of these important principles. I understand that very often proportionality tests are adopted, and basic law court cases, and in the recent Hong Wan-ming case, now, before 2004, 1 year residence would suffice for CSSA, and then after 2004, 7 years. The administration's objective was to ensure the sustainability of the CSSA system. The administration also needed to bear in mind the need to control government expenditure, but all the arguments were rejected by the CFA, and the CFA looked at different yardsticks, for example, aging population and so on and so forth. And in future, there may be a court case where the principles in the basic law are subject to the weight according to the proportionality test. And so it's more and more important that we study these principles very carefully and explain in detail why this policy is needed, and if there are policies which contain elements which may do a blow to these important principles, such violations or impacts should be minimized and the duration should be kept as short as possible. So any government intervention should be restricted to the minimum and also the minimum period of time. Now the sunset clause is important. Say if in future the administration's policy is challenged, then these short-term measures, including the sunset clause, can serve as defense for the administration. It's obvious that the administration has in this case engaged certain principles in the basic law, and whether such intervention, such violation can still be tolerated, I think a sunset clause would help a lot. Concerning, and I think because of external factors, other factors including the tapering of the QE in the US, I think a sunset clause will help justify the government's intervention. So I think if there are provisions which can restrict the government's intervention into the market, they should be supported. And in fact, I think that the rates can be updated on an annual basis, as Mr. James Toh has said. Previously we did have tax control. I think for short-term measures affecting the business sector, including the import and export order on powdered formula, all these measures which affect the business sector and also members of the public should be considered very carefully. In fact, in the UK, every time there is a call for government intervention, the government asks whether there is a need to insert a sunset clause in the relevant legal document. Thank you. Mr. Albert Chan. Thank you, Mr. Chairman. I think in dealing with this bill, we need to bear in mind two areas or two sets of values, and we need to make a choice between them. In fact, in the last two rounds, I said that the agreement, the secret agreement between the secretary and two political parties jeopardized the dignity of this council and jeopardized the work of the Bills Committee. And so in this regard, we should bar this bill from being passed. We should force the administration to go back to the Bills Committee to have a discussion with the Bills Committee again. But then I want to say that what I said and what Mr. Abraham said represent the interests of different classes and societies. See how Mr. Abraham Sheikh continued to respond, and he resorted to smearing and personal attacks in order to achieve his political objectives. Now, I said he should be called Captain Hong Kong. I don't think he really understands what I mean. Now, in fact, there is this film, Captain America, and the hero is willing to, and is very courageous, is willing to risk his life to fight for his own cause. In fact, I should have called him Hong Kong Landlord Captain and not Captain Hong Kong. I think today he's the bouncer for developers. He has to defend the developers very rigorously and fiercely. C.Y. Leung, who got 689 votes, without consultation and without the support of the major developers, decided to launch a policy which would infringe upon the vested interests of some in society. What are the implications of the policy? Property prices will drop, and the CY Leung has this very good excuse or explanation. He says that he doesn't want Hong Kong people to be affected, doesn't want society to be affected. But then at the same time, we have 54 million tourists coming to Hong Kong every year, most of them coming under the individual traveller scheme. And do you know that this scheme, this influx of tourists, also causes property prices to rise, in particular retail shop premises? But then he has advocated this scheme, and he has supported multiple entry endorsements. In some shops in North Point were forced to close down because of the very high rentals. So you can see that on the one hand, the government legislates to bring down property prices. On the other hand, the government supports the individual traveller scheme and in this way encourages property prices, especially prices of retail shop spaces, to rise. So why is it that this administration has a split mind? And in fact, many politicians also have this have a split mind. They say one thing, they vote in another direction. So please do not judge what 689 does by logic, by reason, by or from the public policy perspective. Whatever he does out of political considerations. So we have these two policies advocated by 689. One is the demand management measures. The other is the individual traveller scheme. So why is it that 689 is continuing to promote these two conflicting policies? I think maybe someone wants to shake the powers and influence of local developers in Hong Kong. And then someone may want to increase the mainland's influence in Hong Kong in every respect, cultural, social, and so on and so forth. I think you've really departed from this present motion. Now, because Chairman, I just want to say that this bill will affect the distribution of power, political forces. Please do not spend too much time making other comments. And this CSA is on the sunset clause, Chairman. And I want to say that there will be certain impact. The political effects may be affected. But anyway, Chairman, thanks for the reminder. I want to say that we have to bear in mind the political consequences. If the sunset clause is not included, then what will be the impact on the effectiveness of the bill? But then we also have to bear in mind the political consequences. I don't have a crystal ball before me. We have to continue to monitor the development in society. For example, the changes or distortions to the social, economic, and political landscape in Hong Kong in the next 3 to 5 years. Now, with regard to people's power, we are caught in a very difficult position when we need to cast our votes. We need to reduce the influence of developers in Hong Kong. We need to protect the interests of the public at large, but at the same time, we need to uphold the dignity of this council. We really have to make this choice, so it's a difficult choice. And then I want to say that with regard to the retrospective effects of a piece of legislation, whether it's fair or not to have retrospectivity, I think there should be retrospectivity only if the situation is very special and that there are good grounds for the law to have retrospective effect. Now, because certain groups of people or certain people will be affected, mostly in an adverse manner, and that will be against the principle of natural justice. And so with regard to the sunset clause and also the retrospective provisions, we will support the amendments because some people might have acted and then if they have to be deprived of the exemption at a later stage, that would be against the principle of natural justice. Mr. Paul Chair, yes, thank you. I would like to state my position on Mr. Dennis Kwok's amendment. This is on the BSD, and it was announced on the 26th of October 2012, and the BSD will come into effect on the 27th of October, and then on the 18th of December 2013, Mrs. Regina Ip proposed an amendment that was on the 18th of December 2013.
On the 7th of January 2014, the LegCo Secretariat put up a request with the government asking for a response. I didn't see the date. It's only in 2004. It should be the 6th of January 2014. That's the date of the facsimile. That's the day when the Secretariat distributed the document to members. Because of various reasons, this proposed retrospective provision for negative vetting has been dragged on for a long time. If you're talking about a short time, we all understand that there's legislative risk, and in the process of scrutiny, there may be changes to the bill. Because of retrospectivity, plus that particular reason, we have to assess the situation. When we assess anything, fairness, yardsticks, and so forth, during our scrutiny, we must also look at this rather long duration. Many colleagues, including Mr. Dennis Kwok, mentioned a fundamental legal principle, that is, there shouldn't be retrospectivity. That happens to many jurisdictions. I don't need to dwell on that anymore. But then I'd like to elaborate, because some of our colleagues mixed up concepts. For example, concerning retrospectivity, past acts and behavior might be considered as unlawful. Then we have to be very careful with such retrospectivity. And normally we shouldn't do that. As for some past occurrences, what consequences there would be, what follow-up action should be taken, the retrospectivity is different in nature then. For special needs, normally for tax revenue, because of the sensitivity of the market, we may have to have the government express its stance and policies before we complete the legislative process. That's another kind of retrospectivity. So we have to clarify which one is it. Different occasions, different nature, different duration should be measured by different yardsticks as to under what circumstances we can be more lenient and under what circumstances we shouldn't give in even an inch. Chairman, I think there's one point we need to pay attention to this time. For these amendments concerned, they are not passing through the scrutiny process of the so-called legislature. Of course, these amendments are now moved by members. However, originally, the administration did not change its policy, but then when it faced unforeseeable scenarios and the administration's policy may be voted down or members' amendments may be supported, so the government was forced to make a policy change. Of course, behind all these, did the administration talk to Mrs. Regina Ip? I believe there's some communication between them. They try to find a way out, and somebody may want to steal the limelight. However, it's not as the government said. That is, the government is not guaranteeing that a boy will be born, so members of the public will have to be careful. In this piece of legislation, there's no guarantee that the policies and provisions will be passed without amendments. Well, if the government is forced to do this, then it may be more powerful. But when I communicated with the officials, I understood that point. The ordinary public should understand the risk. But in this exercise, in terms of attitude and policy, the government has made an about turn. If the government has thought through this in detail, it will not have to face this dilemma. But then previously, the government said very confidently that the original bill was in compliance with the law and the basic law. It had sought legal advice and found this bill worthy of scrutiny. But then during the scrutiny process, a lot of loopholes were identified. As our colleague said, very often we had this happen. But then procedural delay may lead to somebody, maybe not too many of them, having relied on the government's announcement of policies and may have their transactions and behavior affected. So, Chairman, we have to be very careful about this. I mentioned negative vetting just now. And then we have to consider the delay, a prolonged delay, with a long scrutiny process, and members of the public suffered from a longer time of uncertainty. Well, this is not what the government has foreseen. It has not foreseen that it might not get sufficient support. It had not foreseen that members' amendments might be passed. Therefore, the government was forced to change its position. Of course, it has packaged its position like that. The fact may not be so. Anyway, we'll have to consider this situation. And then we heard some remarks about lawyers' firms who spoke on behalf of their clients. Even if it cannot be fully guaranteed that the parties concerned would not, like what Mr. Dennis Kwok said, be deprived of their exemption upon the enactment of the bill, we should consider the original intention of the government in making this change. That is, on the 6th or 7th of January 2014, the government had made a detailed deliberation on the subject matter, and after members have had a better understanding of the situation, the government would like to make a change. So maybe that date should be made a cut-off date. Of course, that's not the content of the amendments that are now tabled. In a moment when the administration responds, it should explain how it's going to handle the situation. There are special circumstances that may warrant the amendments. As a responsible government, it should consider this. In law, I mentioned the policies and principles and legislative fundamentals. That is, before enactment, a bill remains a bill. and members of the public should understand that risks are involved. Generally speaking, this principle is correct. It's rather difficult to challenge in law this practice of the government to see whether it has acted against the law and whether a judicial review can be sought. But as a credible government and trustworthy government, if the government wants to boost its positive image among the public, the government has to be careful. Any act under special reasons to cope with special scenarios should be handled carefully. Any victim should be appropriately handled because this situation is the result of the government's acts. Mr. Yuk-man, the 4th and 7th of the items of amendments moved by Ms. Tari Lee involve a number of matters. One is the sunset clause. Another one is to have a sunset clause for the BSD, and the other one is for SSD. Now, first of all, I do not support a sunset clause for the SSD, but I support a sunset clause for BSD. Starting from the 20th of November 2010, any residential properties obtained after that date, and in 24 months' time, if there's a transfer, 5 to 15% of conveyance stamp duty will have to be paid. That is to tackle the overheated property market. By the SSD, buyer's cost will be increased. But in terms of housing policy, the ultimate objective is that you hope that Hong Kong people, Hong Kong PRs, can successfully own their own homes in such a property market. So you would like to curb the very heated and speculative property market. That objective is very clear. For the SSD and the rationale behind it, I don't quite accept it. You say you cannot foresee future market changes and no single indicator can reflect the basic situation of the property market, blah, blah, blah. The government has apparently neglected the original meaning of the SSD. It is to target the overheated speculative property market. It also wants to tackle the demand side of the market by curbing property prices. Yet now, today, you have to look at the prevailing situation of the property market. Property prices are high because of an imbalance between the supply and demand. Whatever harsh measures you impose, you will not be able to lower property prices tremendously. People are worried about a collapse of the property market. How can the property market collapse? The situation of supply and demand is very clear. Even if you impose a 15% BSD, still there are bound to be people buying properties where they may be speculating, but they can hoard their properties after buying them. So there's no way you can tremendously cause the property prices to drop. As our colleague mentioned, you don't want the market to collapse because you'll die as well. With these harsh measures, will the market collapse? Well, basically, no. It's because of inadequate supply. There's an acute shortage of supply. So why the LTHS Steering Committee recommended the construction of 470,000 housing units in 10 years' time with a public-private ratio of 6:4. You say you cannot foresee the future of the property market. That is not substantiated. In the next 10 years, we'll have 470,000 housing units. So your argument is unreasonable and illogical. Unless Mr. 689 was telling a lie, that is, the government will not be able to build 470,000 housing units in the next decade. And you promised to act on the basis of the LTHS Steering Committee's recommendations. That is to build more PRH units, 20,000 PRH flats and 6,000 HOS flats. Well, unless you're going to renege on your promise, you won't be able to do it because the market is in your hands. We now talk about property hegemony, but the biggest hegemony is the government. You see, Mr. James Tan's company is of a certain scale. He will buy expensive properties and sell at a high price. He will, of course, like to import a great deal of labor so that he can build quicker at a lower labor cost. Well, $10,000 odd per square foot in terms of land premium, then the selling price in future will be $20,000 odd per square foot. For HKPLs, you want them to buy property so that they can live in peace. Well, a couple will have to work very hard to pay the installments. If they earn $50,000 to $60,000 per month, they will still not be able to afford a flat. And Chairman, recently, it said that Hong Kong people try to exclude outsiders. And Dr. Yok Chow said that we should not discriminate against other races. But are Hong Kong people of the same race as the mainlanders? Well, he's absurd. I think he's crazy now. Well, he was crazy when he was the Secretary for Food and Health. Now he's with the EOC. He's still absurd. And all these officials are now crazy and absurd under the leadership of Mr. 689. Mr. Wong, you're digressing. No, I'm not digressing. The whole bill is a bill to exclude outsiders, right? You just dare not say it. This is a bill to exclude outsiders, such that those outside Hong Kong, those non-Hong Kong PRs, will have to pay more in order to acquire properties, to pay 15% of stamp duty. This bill is excluding outsiders. It's just that you dare not say it. The government is taking the lead to do this.
We are talking about the right of Hong Kong PRs to buy property, right? I support it. But the amendments are chaotic, the negative vetting, etc. I will take you to task again when it comes to third reading. Yesterday, there was luck. When Section 16 was to be adopted, I didn't know where I was. Mr. James Toh is now nowhere to be seen. He came to remind me, but I was at a loss. And then he said this would be vetoed, but with Section 16, he said there is the Liberal Party and Abraham Sheikh, and maybe we could veto it. And I said, yes, maybe that's good. I support the bill as a whole, that we should keep out outsiders. You are taking the lead to keep out outsiders. You are taking the lead in nativism or populism. Of course, I support it. But then, Clause 16 will be able to stop you from doing something bad because negative vetting, etc. So I am very angry now. I have to state my stance. I'm very angry. Actually, I did not know what is happening, but James Toh came to remind me, so I told my assistant that he should remind me. Then there was communication problem between us, and I went out to eat, and it was right there at that time. And then I was asking, where is Vincent Fang and two other radicals, and Ronnie Tong and Lam Tai-fai? Mr. Wong, you are digressing. No, I'm taking this opportunity to make an apology. I have to take responsibility for my wrongdoing. Oh, it's good that all of them also disappeared, or else I would be the only bad guy. Well, anyway, this is not about the present debate. Please speak on Clause 17. The protagonist today is, of course, Mr. Abraham Sheikh, and so he is speaking the most. I am not speaking a lot, Chairman, so be accommodating, or else I will speak for 15 minutes under third reading. This is very enlightening. This is 100% xenophobic clause. Xenophobia may not always be wrong, and that is why I'm saying Dr. Yok Chow is crazy. Let me continue. Just now I said that the administration does not have grounds to object to having a sunset clause. You see, we cannot speculate future changes in the market. Well, you tell people there will be 470,000 units to be built in the next 10 years, right? The market is in your hands. What are you talking about? such supply of 470,000 of private and public housing in the next 10 years, there will be this change in supply, wouldn't it? Unless you are telling me that you are again cheating the people. If the administration's promise of 470,000 units will be delivered, there will be a downward trend in property prices, and the SSD and the BSD would dampen the desire for Hong Kong PRs to buy property. When Hong Kong's purchasing power can take care of prices, in other words, there will be a lot of PRH, there will also be HOS, they are in the market, they are taken up, then you should cancel the SSD, right? And I'm looking at this from the perspective of xenophobia. But the BSD is different. The BSD targets non-Hong Kong PRs so that their property cost or speculation cost will be higher. As the administration always says, Hong Kong's economy is an externally oriented economy, so it is easily affected by volatilities in the external environment. If there will be a sunset clause for the BSD, it would amount to allowing speculation to revive. But the BSD is to increase the speculation cost for people who are outside Hong Kong, but not the normal home purchase activities of Hong Kong people. Indeed, there is a lot of hot money in the economy. So even if the BSD is an extraordinary measure for exceptional times, the BSD should not be cancelled in the short term. Okay, you're talking about extraordinary times, but it may not be for 2 to 3 years. Therefore, when you set the sunset clause now, we are not going to accept it. This is our very clear stance. We support having a sunset clause for BSD, but we do not think there should be a sunset clause on SSD. Thank you. Mr. Lam, Tai-fai. Thank you, Chairman. I understand perfectly the original intent of taking these demand-side management measures, and that is to cool the market and suppress property prices, and also to reduce the risk of a property bubble. That I understand. So when the administration says this is an extraordinary measure for exceptional times, that it is a temporary measure, I can understand and agree to it. But you must understand also, the administration, that any policies will have pros and cons. There is no perfect policy in this world. Even if there is a very good policy, there may be negative consequences and side effects. So you cannot be too rigid in enforcing policies. And you should not say policies are always good for continuation. After the policy was made, many people criticized that it distorted business behavior and it dampens Hong Kong's free economy. Administrative intervention has given rise to a lot of debate. So implementation-wise, I hope you will have more flexibility and vary the measures according to the situation. And timing is one such factor. As I was saying, even if it is a very good policy, there are pros and cons. There may be side effects. The property market is like a cancer, and like cancer growth, and your target medicine may be effective for the interim, may not be for the long term. But then the target medicine is good for curing cancer. However, it can still cause suffering for the patient. The hair may fall and there may be vomiting, etc. So you have to understand this. Just now, Mr. Yuk-man says this is a xenophobic policy. I don't think he is that wrong, but I don't agree with him. I think it is only semi-xenophobic at most. We have a different concept of the country. He views mainlanders as outsiders, but frankly, I view all mainlanders or compatriots our fellow countrymen. So I won't say this is a xenophobic clause. In fact, this will affect non-Hong Kong PRs, including mainlanders and foreigners. So it is semi-xenophobic at most. But I would call it a policy to turn away clients. It is just like the two-tin rule governing baby formula. If there will be a tobacco duty increase, you are also increasing the number of tobacco sticks people can use. So you are turning away clients, and who will be most happy about this? And when I talk about this, I will of course have to mention the sunset clause, or else the chairman will stop me. If there is no sunset clause, who will be most happy? Our neighboring countries, because people will go and invest in those places. Those who are always said to be interfering into Hong Kong's business, like Europe, the Americas, etc. These people will go, investors will go to these places and also to Japan and Singapore. If they have gone, they won't come back tomorrow. If you go to a cafeteria and they turn you away, maybe tomorrow you don't want to go back again. So there will be consequences, and therefore there must be a timing factor to continue. And you must stop turning away clients by a certain time, or else you will have to close shop. You cannot allow these measures to go on forever. Mr. Chairman, please, you correct my Cantonese pronunciation. Please do not let Mr. Yuk-man correct my Cantonese pronunciation. I was made a fool just now. But the chairman said, apart from Mr. Yuk-man, nobody could turn away clients just by what he says. Of course, that's a pun in Cantonese. Just now I was talking about people wanting to buy property basing on their own values in life, etc. And I talked about that in the last session, and now I would like to look at this from a macro angle. I really have to distinguish the pronunciation of the two Chinese words, gong and gon. Please, I am from Chiu-Chao. Please do not, or pardon my Cantonese pronunciation. Right, please do not digress anymore. Thank you, Chairman. If there is not the sunset clause, apart from the economic development or financial crisis, there would also be a political crisis. It may also be a blow against one country, two systems. Why do I say this is a political crisis? Well, actually, you don't write it in the bill, but actually you are targeting mainlanders who invest in Hong Kong, right? It is in the press that mainlanders are now wealthy. There is an economic takeoff, and so they come to Hong Kong to buy property without setting up a mortgage. Frankly, you dare not write this down in the bill, but you are targeting mainlanders. You want to add to their cost. In the past, the central authorities rolled out many policies to favor Hong Kong compatriots. Why do we want to roll out a policy to make it more difficult for mainland compatriots? Now, the public may not know what I'm talking about. The thing is, you should go for an increase in supply to cool the market, not by an increase in tax. And you are taking such broad brush measures to even ban Hong Kong PR companies from buying property. Mr. Lam, you are digressing. No, I'm talking about the sunset clause and that there will be a political crisis. Without the sunset clause, the taxes are making many mainlanders, especially the investors, angry. They say that the country is favoring Hong Kong. Why is the Hong Kong government so stupid in targeting mainlanders? Why don't you target foreigners? You say foreigners should pay more taxes and mainlanders don't. So all in all, you are targeting mainlanders. If this kind of antagonism goes on, the relationship can deteriorate to such a point that it will break. Therefore, there must be a sunset clause to tell them this is an extraordinary measure in exceptional times, so hold it, don't buy now when I can find sites for building PRH and HOS, and I can sweet talk the developers to release private housing, and the flour may be expensive, but the developers would be asked to make bread with a cheaper price tag and help the administration to have good governance and give me 3 years and I will be able to roll out many development estates. You have to complete your negotiation within 3 years or else Hong Kong people will be victimized. So this is what we mean by a sunset clause. With the sunset clause, with a time limit, we can force the administration to do something and to increase supply and to release sites and don't just pay lip service. The CPG will tell mainland investors, okay, hold it for 3 years for the sake of prosperity and stability of Hong Kong, for the sake of Hong Kong people ruling Hong Kong, give them 3 years. Hold it. Don't get angry in the meantime. So timing is important. Patience is limited for everybody. And Mr. Chairman, don't say, please, I am digressing, because this will also deal a blow to one country, two systems. You know, Hong Kong has a capitalist system, but in China we have, or on the mainland, we have socialism with a Chinese characteristic, and it is not like a planned economy. Please do not digress. No, I'm not digressing. Let me explain to you. Please come back to clause 17. Yes, sunset clause, sunset clause, sunset clause. What I mean is, the CPG asks us not to interfere into the market, and the market should adjust itself. Self-adjustment is most natural, is most effective. But now we're interfering into the market ourselves, right? Of course, the CPG knows that this is an extraordinary measure for an exceptional time, but it wants you to put a timing factor to it. Or else, if you adopt a socialist system, what will happen? There will not be one country, two systems. It will not be successful. There will just be one country, one system, and total integration. And you go for a socialist system, and the mainland goes for a capitalist system and open up the market, and there will be just one country, one system. So there will not be one country, two systems. Then there will be total integration without having to wait for 50 years. So, Secretary, you must put in a timing factor to prove indeed that your intention is for the intervention to be time limited, that it is provisional. And you must tell the CPG that you don't want to change your capitalist system, that you don't want to go down a socialist route with characteristics. We don't want to have a planned economy or interfere into the market. We don't want to go against your instructions. Not that we want to make it the other way around just because you are far away from us. So there should be a timing factor.
We do not want to affect Hong Kong's future business development. We do not want to see political crisis created. We do not want to jeopardize one country, two systems. And so I think there should be a sunset clause in relation to the BSD. Thank you. Mr. James Toh. Yes, Mr. Chairman. There is one point that I haven't made, and that is some members, including Ms. Dari Lee, and also the Secretary, in fact, said that there shouldn't be a sunset clause. And this is because no one can predict when the administration should withdraw from the market. No one can predict when this bill will no longer be necessary. And no one has got a crystal ball in his or her hands. Now, there are many types of sunset clauses, but then here we're discussing 4 types, all right? So we're not talking about 9 months later, 1 year later, 2 years later, no. We're not talking about that type of sunset clause. And no, what we're proposing is that the LegCo or the Secretary can make an amendment. And we're not proposing something like no more than 2 years. So in fact, it's really a very accommodating sunset clause. Now, if there is a need, and then if there is agreement, then we can amend it to read another 3 years, another 5 years. So I don't think it should be another 10 years. It is not that on a certain day the duty will automatically lapse. And in fact, and also, even if we specify a date, then maybe we can pass a bill before that day, and the duty will continue, because we can introduce a bill to amend any piece of legislation. But then here we're talking about subsidiary legislation, so I don't think it's really convincing to say nobody can predict when this bill is no longer necessary. I think the purpose is to state very clearly that this bill is different from the other bills without a sunset clause, because for the other pieces of legislation, they will continue to have effect until and unless there are amendments. But then for this bill, it represents a special measure, an extraordinary measure for extraordinary times. So it doesn't mean that with a sunset clause, the duty will automatically lapse on a certain day. No, that's not the case. And then some members say that we are merely discussing these 4 types of sunset clauses and not other types. Of course, I understand. But I think these 4 types do contain the main characteristics of the sunset clause. And what are the differences? Now, Ms. Starry Lee is the chairman of the Bills Committee. She hasn't explained the 4 types or the 4 scenarios. And then members who suggested the sunset clauses in the Bills Committee, hoping that Ms. Starry Lee would move the amendments on behalf of the Bills Committee, did not really explain the 4 types. Now, let me first of all talk about the first type, type 1. 31st December 2014. Now, Chairman, the DP thinks that that would be too near to the present moment. In fact, Mr. Tommy Cheung mentioned 2 years from the introduction of the duty. But then as for the secretary alone to move an extension. And then the second amendment, LegCo. In other words, members or the secretary can move an amendment. And the date is the 26th of October 2015. And then type 3, 31st December 2014. That's Annex or Appendix 7. 31st December 2014 for BSD. And then for the secretary to move. And then next one, 26 October 2015 for LegCo to move an amendment. Some members may think that only the administration and not LegCo can move an amendment. Then you should support the type on moving the amendment by the administration. But in my view, I think LegCo should also have the right to move an amendment. Let me talk about rent control. And in fact, on one occasion when the rent control was extended for 2 years, I was involved in moving the amendment. At that time, the Secretary for Housing was, I can't remember his name. He said that LegCo should not have put forward the proposal, but then ultimately rent control was extended. And now, of course, if the secretary wants to propose an extension in the future, he has to convince LegCo members to support him, and he has to explain why the date he proposes is acceptable. Because if the date is in the very near future, members will not support that. If the date is in the very distant future, again, members will not support that. So usually, we're talking about 2 to 3 years. If the administration believes that it will need to withdraw from the market in 2 to 3 years' time, then it can consider doing so by subsidiary legislation. But then last night, Clause 16 as amended was passed. But then you can just simply change the rate to 0. And if you want to extend the duration, then you can do it by way of subsidiary legislation. If you want to stop the arrangement, then you just change the rate to 0. Does any other member wish to speak? Mr. Dennis Kwok, do you wish to speak again? No, thank you, Chairman. Secretary, do you wish to speak again? Chairman, the administration cannot accept Mr. Dennis Kwok's amendment concerning the exemption for guardians and trustees acting on behalf of minors. I will speak on the administration's position. The committee has passed the amendment which was originally proposed by Mrs. Regina Ip, and that relates to the withdrawal of the BSD exemption for trustees and guardians acting on behalf of minors in acquiring residential property. Now, the amendment was to address concerns raised by Bills Committee members. Members were of the view that the mechanism would be subject to abuse quite easily, and as a result, the effectiveness of the BSD would be reduced. Sorry, please pause, Secretary. We'll have a quorum count.
局長。
Secretary. Chairman, I'll continue. Concerning Mr. Kwok's amendment, it is to propose that the amendment should not apply to transactions before the gazettal of the enactment of the bill. The government cannot accept this amendment. In the original bill, there are a number of exemptions. These exemptions represent the implementation measures on the part of the government. Before the enactment of the bill, in the legislative process, there must be due discussion, and the contents of the bill may be changed. If the LegCo is of the view that there is a need, any amendment can be moved. Members of the public should not have this unreasonable expectation that the bill will get enacted with no amendment. Given what Mr. Kwok said, indeed, this bill is about the BSD and the enhanced SSD. These two duties are extraordinary measures during extraordinary times. Therefore, this bill will be retrospective in certain respects. Any law and any bill, for the sake of uncertainty, reliability or non-reliability, there may be amendments. Cite this bill as an example. Up to this moment, we've been deliberating on the bill for over 25 hours. But at the end of the day, whether or not the bill is enacted is still unknown. Therefore, it is very difficult to ascertain how we should view certainty. Many members of the public will expect the bill to be enacted eventually. But if it does not get enacted, whether there's legislative certainty or uncertainty is difficult to explain. For minor HKPRs, for this exemption amendment for the BSD, the government acted on the basis of the views presented by LegCo members and other stakeholders, and we're actually responding by moving this amendment. As for other amendments, we do move other amendments. For example, to improve the BSD mechanism for redevelopment project. Finally, the administration has accepted the views of the Bills Committee and has moved an amendment. Members have also moved different amendments. Some of the amendments are for the objective of expanding the exemption arrangements under the bill. Others aim at tightening the arrangements. If these amendments are passed, then starting from October 2012, those affected by the new measures may claim that they're being affected. Therefore, in principle, we're of the view that it's only after the LegCo has completed its scrutiny and legislative process and the bill is gazetted that we can implement the enhanced SSD and BSD regimes. And the operation will then actually come into being. We do not think we should apply the administration's amendments to those occurred before gazettal. That's what Mr. Kwok mentioned. That is, minor HKPRs through their trustees or guardians purchase domestic properties. That's not in line with the legislative intent of the bill. And members of the public may have different misunderstandings about BSD. Well, there may be potential loopholes, but if we allow certain transactions, no matter how many there are, to enjoy the exemption, the administration and the Bills Committee have the same objective of granting certain exemptions. And then we may be providing an incentive for certain parties to make use of the loopholes, to make use of minor HKPRs to procure properties in order to evade BSD. Mr. Kwok's amendment, if passed, may affect the period before the gazettal of the enacted bill. It may be just a few days' time, but millions of properties and 50% of BSD will be affected, and we're not talking about a small sum of money. Therefore, the government cannot accept Mr. Kwok's amendment. I'd like members to cautiously consider the administration's concerns. Previously, the IRD on its website in the Q's and A's clearly pointed out that stamp duties will be implemented after the legislative process for the bill is completed. The government accepted Mrs. Regina Ip's amendment and notified the LegCo. After making that decision, the IRD immediately updated its website to inform the public. Ms. Dari Lee, on behalf of the Bills Committee, has moved a sunset clause in her amendment. As we said, the government does not have a crystal ball. I'm not repeating what we've said, but the truth is that we cannot speculate on market changes and external factors and then casually and randomly set a date in 1 year's time or 2 years' time in order to decide when we no longer need to apply the measures. Any sunset clause will be sending out a wrong message to the public. Objectively, that will fuel demands, adding to the volatility of the market, thus weakening the effectiveness of the demand-side management measures. Some members asked, what indicators did the government use to decide on the future adjustments or withdrawal of the measures? The government will, of course, give regard to indicators and closely monitor the situation of the property market. The property market is affected by many external and internal factors: macro economy, interest rates, capital flow, demand and supply in the market, etc. The government will refer to various indicators to closely monitor the market changes. That is not confined to property prices, affordability, number of transactions, supply and demand balance, or the growth in mortgage loans, as well as changes externally and internally. We'll also refer to measures adopted by other jurisdictions in accordance with market changes, which may impact on us. The European and U.S. countries in QE tapering. Therefore, there are a lot of factors affecting the property market. They are complicated and are subject to a lot of changes. They're also interactive. Some factors may impact on other factors. There's no one single indicator that can allow us to, in a simple manner, quantify our indicators so as to assess the situation of the property market. Therefore, the government cannot and will not just look at individual indicators in making decisions. Of course, we have to refer to relevant indicators and their interaction as well as trends generated in our overall assessment.
I have said this in the past, and I'd like to repeat this. After there is a balance in supply and demand in the market, we will consider adjusting these demand-side management measures. I made the promise in the Bills Committee, and today I make the promise again. After a year the bill is passed, I will give an account to the review of the measures. Now, of course, when we do the review, we will analyze with you again how the administration views our internal economy and also the external environment. I ask members to veto Ms. Starry Lee's amendment made on behalf of the Bills Committee. Now, I put the question to you, and that is that the amendment moved by the Secretary for Transport and Housing be passed. Mr. Ibrahim Sheikh calls for a quorum. Do you have a question? What is the question that has been stated? The fourth amendment moved by the STH to move clause to amend clause 17, page 76 of the script.
저기다.
The question is put to you, and it is that the fourth amendment moved by the Secretary for Transport and Housing be passed. Will those in favor please raise your hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. I have told members that this session will have to be adjourned at 2 o'clock. I think we do not have time to tackle the next vote. We will adjourn the meeting now until 8 p.m. today.